an appeal in the matter of the Secretary of State from Ryan Lieven Law Affairs and others, and SMAR Holdings Limited and others.
Simons.
Good morning. My lords, my lady, I appear for the Secretary of State, obviously the appellant in this appeal, along with Mr. Appellant. Mr. Hugh Richards appears for the respondent alongside Miss Allen, who sits behind him. Just to check on the bundles, there's for this one a different core bundle and a different supplementary bundle as well, of course, to yesterday. Same authorities bundle. On the supplementary bundle, just to confirm, it now should go up to tab 19. There was an addition to it later on in the day.
There is 15 still.
Aha! You're going to...
we did have extra material come in.
Yes, those should hopefully, along with, I'm hoping, a new or a
no, it's my fault. I remember telling my clerk not to worry now. Yes, I've got it, yes.
It's, the new stuff it follows on sequentially in tab numbers, so it just goes tab 16, 17, 18, 19.
You just pop those in.
Not
Whilst I'm doing that, can you just remind me where I find the objection? Not the submissions on the objection or the description of the objection, but that thing which in life is the objection. Or my lord thought he'd found it, I couldn't find it.
I will be told, but my little friend, that the objection sits, as I understand it, at tab 10, of the supplementary bundle, and then that then goes along with and introduces the submissions that I think my learned friend wrote that start at, I think, tab 11. So my answer is tabs 10 and 11 of the supplementary bundle.
I think it's page 21.
Oh, sorry.
By the way, we don't have tabs.
Oh, I see. I'll do
that's bear that in mind.
So I will, but thank you for that. I will bear that very much in mind. So I'll just give page numbers instead. So in the supplementary, it's all in the supplementary bundle, I think, is the first thing to say. And then the next...
I think it starts at page 15.
It does, sorry, yeah, I gave the wrong...
Stokes Morgan...
That's correct.
Yeah.
Sorry, I gave the wrong one. It's at 15, and then there's something called a statement of case, which starts on page 17.
Go slower, Mr. Simmons. I haven't even got to the first of the three documents.
I'm sorry.
So there's no point. Start again.
I'll start again. Sorry.
Take us to the objection. We'll rewind, and the question I asked is, where is the objection? So
start at page 15.
That.
15 of the supplementary bundle. That was what the reference I did.
As we
sorry, I'm probably being really slow.
Not at all.
I can't.
Just to be clear, in case the page numbering on the supplementary bundle, the relevant page numbering, because each page has about 5 different numbers on it. The relevant page numbering is in the centre at the bottom. So that all the page numbers on the right-hand side are OTOs from previous bundles and proceedings. So it's the central number. Start at 15 and then go through. The next document starts at 17.
Sorry, are we looking at what do you objection to restocking notice?
Yeah. Yes. So page 15.
That's tab 10. That's page 67.
Yeah. So.
No, that's additional submissions actually.
Precisely. So
this document it looks like that.
Okay, got it.
I will work these. I will go through these in chronological sequence in a few minutes. But yes, page 15 is a letter, and then what went along with that letter is something called a statement of case. But
before you get there, page 16,
exactly.
We have Form 6A, which looks to be the prescribed statutory form.
Correct.
For objection.
That's right.
Counsel for the Secretary of State yesterday said did not exist, and she was not aware of any prescribed forms. So that's why I'm finding it puzzling.
I see. There are prescribed forms in regulations that the court only partially has before it. There are prescribed forms.
Well, my recollection is we did ask counsel this yesterday, my lord asked.
Yes,
and we were told the exact opposite. We were told that counsel had checked and there were no regulations.
Well, I think
Not sure
what she said was that she didn't think there was anything in the regulations or the forms which would help us on the issue.
I think that was my recollection of what she said. There are indeed prescribed forms, and essentially what you see, we can obviously provide the full set of regulations. The court only has an extract from the relevant regulations. You don't have the form before you, but the form looks an awful lot like the Form 6A that's at page 16.
We'll let you go back to your routine, but I just was puzzled by all of this.
No, of course. Obviously, it was a useful question.
The form itself refers to the statement of case. And
yes, it does.
And so it is.
On this occasion, so.
Thank you. In terms of what I intend to do this morning then, just a few minutes by way of introducing what I say is the issue that the court is being asked to grapple with, by way of introduction. Then briefly the facts, just to run through points like the one that my Lord's just put to me about what happened in what order and where it all can be found. Very briefly on the judgment, because the judgment below, because I understand that the court's already read that several times, but I'll just alight on the critical paragraph in the judge's reasoning, because there really is one paragraph that gives rise to this appeal. Some brief submissions on the law, again appreciating that we've seen the statute quite a bit yesterday, but there's just a couple of extra sections that I'd like to dwell on that weren't so relevant to yesterday's appeal. And then finally, and hopefully by then briefly, drawing all of that together into my core submission. So, by way of introduction, this appeal is about whether a particular factor was a material consideration for the minister in taking a decision about replanting unlawfully felled trees. The consideration at issue is this: a so-called general public interest in the delivery of housing. That was the judge's phrase. The question for the court is whether that so-called general public interest was so obviously material to the minister's decision that her failure to give weight to it was unlawful. Now, to crystallise, again, an introduction very briefly, how that issue arose and arises for this court on the facts. As I'll show the court, the respondents in this case unlawfully felled a number of trees in a woodland outside Bristol in 2019. The Forestry Commission, who of course are the relevant regulator, issued a restocking notice requiring that area to be replanted with new trees. The respondent appealed against that notice to the minister. There was, just as yesterday, a contested hearing before a reference committee. That appeal was unsuccessful. The minister decided in short that the interests of good forestry required the area to be replanted with trees. I'll show the court that in just a moment. However, and here's the nub, there was, so the respondents said and still say, a chance that this area might be subject to planning permission at some point in the future to be developed as part of a wider housing development. There was then, and indeed there is now, no certainty that this will in fact take place. The Forestry Act, as I'll show the court, is clear if and when trees can be felled to facilitate things like housing and other sorts of development, obviously, under a planning permission. This would not be one of any of those situations. I'll show the court what those situations are, but none of them are relevant to these facts. Below, in a nutshell, the judge quashed the minister's decision on the basis that there is a so-called general public interest in housing delivery, which she found had to be weighed by the minister when deciding whether to refuse the respondent's appeal against the restocking notice. And what I hope to show the court is that the judge's logic rests on three premises, and each one we say is wrong. Each of the three premises is incorrect. The first premise is that there is indeed a so-called, quote, general public interest in the delivery of housing comprised somewhere in the English planning system. We say that doesn't exist. The second premise is that if so, which is to say if there is such an interest, general public interest, if so, that the Forestry Act permits that interest to be considered as part of a decision about restocking notices. We say it doesn't. And third, even if it does, even if there is such an interest, even if it is permitted to be considered, so if 1 and 2 are answered in the judge's favour, if you like. Third, on the facts of this case, that general public interest was so obviously material that any minister acting rationally would have had to have taken it into account. We say on the facts that I'll elucidate in a moment that's incorrect. The core response and the reasons that sit behind our opposition to those three premises are comprised in 6 brief points, a couple of sentences each that I'm just going to set out an introduction now and obviously develop as I go. What these 6 points all go to is a point that the senior president made in Arnold White about the interaction between two statutory regimes that are completely different, that focus on different considerations other than the extent to which Parliament expressly provides. So that's the sort of the core thesis. But to elaborate on that with 6 short points in introduction. Number 1, the Town and Country Planning Act is one of many regulatory regimes in this country that govern the use of land. I won't try and do a list because this court will be far ahead of me, but there are obviously too many to mention, but there are several. The Forestry Act is another, of course, so those are 2. There are many more. These regimes are separate. They fulfil different statutory purposes. They are, of course, obviously, guided by different considerations. No one regime has primacy over the other unless and to the extent that Parliament provides in statute, as indeed at times it has done here, and I'll come to that. That's the first point. The second is that the purposes of the Forestry Commission are expressly set out in the Act. We'll come to them in just a moment.
Say that again.
I'm sorry, my lord. The purposes of the Forestry Commission are expressly set out in the Act, by that I mean the Forestry Act, along with the relevant considerations for issuing restocking notices when trees are unlawfully cut down. The Forestry Act, of course, says nothing about the need for the forestry regime to support or indeed recognise any general interest in housing delivery. That's the second of the 6. The third is that the relationship between these 2 regimes, the Forestry Act on the one hand, the Town and Country Planning Act on the other, is set out expressly in a number of key statutory provisions, in particular, as we'll see, just two obvious examples, Section 9(4) and Section 15 of the Forestry Act. There are also provisions in the Town and Country Planning Act. None of those provisions are engaged on the facts of this case. That's the third. The fourth of 6 is that whether there is indeed a so-called general public interest in the delivery of housing on a particular site is the role of the planning process to determine. That is, in effect, the outcome of the planning process. That's what the planning process is there to decide, to adjudicate on, if you like. That output cannot be anticipated or assumed by a different regulatory regime, in this case the forestry regime, in advance of the planning process reaching any relevant determination on the question whatsoever. That's the fourth. The fifth of 6 is to take that point, the fourth point, a step further. There is no general public interest in favour of housing development over other interests, like, for instance, environmental protection or the protection of trees in the planning system. Indeed, for what it's worth, the respondents in this case have for years and are still unsuccessfully trying to promote their site, not for housing, but for commercial development. So any theoretical interest in housing development, which the judge below thought was important, is in fact irrelevant to the facts of this case anyway, as I will show the court in more detail in a minute. And sixth and finally, the threshold for quashing the decision in this case is a high one. A general public interest in housing is not expressly identified in the Forestry Act, I've said that already, as something to which regard must be had. And because there's no express identification of it as a consideration in the statute, applying the run of cases, Creed, NZ, I mean the court's very familiar with all the way to Friends of the Earth in the Supreme Court recently, even if as a matter of statutory construction the Minister could have had regard to the need for housing as part of the restocking notice decision, that doesn't mean that she was required to give weight to it. That's a whole nother leap. A decision which fails to have regard to or give weight to a matter can only be quashed if the matter is so obviously material that no minister acting rationally could have failed to give it weight.
Well, I think you're merging a number of different things there. Actually, you can look at a mandatory consideration and say, yes, it's mandatory. I must have regard to it, but the weight I give it is nil.
That's essentially what happened in this case. The consideration relied on by my learned friend and that the judge criticised the minister for in this case. This is different to yesterday, obviously, where in this case it was looked at. It's in the reference committee report, this point about the public interest of planning and all of that. And the minister, or the reference committee then adopted by the minister, as you'll see in a moment, says, I'm not going to do anything with this, I'm going to give it no weight. That
will be critical, or it may be critical, it may be a question of what they actually did with it.
Of course, so we'll come to that in a moment. But just for now, an introduction on the assumption that that's a fair characterisation of what happened, we are in quintessential rationality territory. There's a consideration, it's in the letter, how much weight you give it is a matter for the minister.
The other problem that I have at the moment is this is a process.
Yes.
Notice is issued, there is a right to object, and we've now seen a form which incorporates certain grounds, and the question is, has the process dealt properly with the objection? It may not necessarily be helpful to wander into areas of what is and isn't a material consideration. It may be a question of us asking quite simply, what was the objection?
Yeah.
Was it considered?
Fine. And in this case, I've got perhaps an easier run of answering that than Miss Sargent did yesterday, because I don't know the papers yesterday so well, but in this case, there's no deficit in reasoning. It's all there on the page, as I'll show the court in a minute. It really comes down to the respondent and the judge saying that the minister was somehow required to give some sort of weight to or more weight, or any weight, to this consideration. And that is where I say that the statutory scheme neither really permits or certainly encourages the minister to do any such thing, for reasons that I'll get into in a moment. But I appreciate that distinction. Right. So that was all I wanted to say by way of introducing the matter. If I could take the court, and I do appreciate, obviously, that the court's had time to appreciate the facts in some detail from the questions that have already been asked. Just a couple of quick references on the facts, just to make sure that they're all before you. Almost all in the supplementary bundle. The site itself is at page 117. There's a red line ordnance survey map. That is in its existing state as a garden centre. For a description of that status quo, the court has it in a few different places, but there is just for factual reference on page 95. I say for factual reference because this decision letter of a planning inspector comes after the relevant decision in this case, so I'm not relying on it for anything other than just what's said in the paragraph.
I wouldn't rely on a description that came many months after. If you're going to give us a factual description, I'd much prefer one that was contemporary.
Fair enough. No, of course, fine. A factual description that doesn't come after can be found. Let me just get it. It is.
You could perhaps get
I'm
it
trying
from
to find
32, but...
32, I'm just trying to find it in the Forestry Commission's reps. I know it's here, but I just can't.
Well, that's page 32.
Oh, there it is. Yeah, there we are. So, perfect. Thank you, my lord. Yeah, 32, under the heading background. It's a site that's on the edge of Bristol, as I've said, to the south of the Bath Road. It forms part of what was the Wye Valley Garden Centre. It's within what's called the Avon Green Belt, which surrounds both Bath and Bristol. And the owner acquired the site in September 2018. That sale was completed in January of 2019, and the felling begins in February of 2019, as is all recorded on that page. Worthwhile, we're on that page, noting what's said at the bottom of the page, on page 32. At the time that felling happens, which is in February of 2019, no planning consents or applications at the time of the felling, but applications have been applied for since, none of which approve the removal of trees, and we'll come back to this under the statutory scheme, that even if subsequent permissions were approved, they can't retrospectively approve felling. Just so that the court can see what the felling comprised in this case, there's a series of photographs before and after from page 24 of the supplementary bundle.
Yeah. They're virtually impossible to decipher. They're black and white in the photocopy.
Sorry about that, but hopefully what you can see is that at least on page 26,
there's an empty patch, and on page 29 there's a non-empty patch. Yeah, so it's the same patch.
Well, then on page 26 you get the 2018 version and the 2020 version. I'm not sure how your printout has been done, but hopefully you can see that a significant number of trees cease to exist, and you've got essentially a bare site that's then in use for essentially commercial storage operations from 2020 onwards. At the time that felling happened, as I've said, there was no application or permission, whatever, for development of this land for housing. What there was, and what there still is a consultation. At that stage, the consultation was the March 2019 version of the consultation in respect of the then and indeed still emerging Bristol Local Plan Review, what's called the Bristol Local Plan Review. The first step in the Bristol Local Plan Review was what's called a Regulation 18 consultation. That's the first statutory step of many in the consultation on and then ultimately adoption of new local plan. We have a couple of versions of this consultation, which I can take the court to, just so you can see the one that was extant, well, at least from March of 2019, so it slightly comes after the felling happens, it's on page 6 of the supplementary bundle.
Was there one at the time of felling?
I don't believe there was. I'll be corrected by my learned friend. Don't believe so.
Just remind me why we're looking at this. How is this done?
Because this is the and the only basis upon which it said that there was some sort of prospect in the future of housing development on the site to which the minister had to have regard. I make submissions about that, but anyway, so this is just factually why it is that we're even having this discussion. You can see, the court can see on page 6, this is a consultation March of 2019, and if the court has a look at page 8, one of the things that the Bristol Council were, and indeed still are, consulting on is it's being examined. Yes, sorry, the consultation process has led to a plan examination that's ongoing at the moment, just to bring us up to date, is the potential for this site, and the court can see this site towards the right-hand side of the photograph at the top of page 8. This site is part of a wider area of land that may or may not come forward in the future as an allocation for housing and other things, a new neighbourhood, and at that stage it would be released from the green belt and allocated for whatever uses the plan thinks appropriate.
In the notice of objection at
Yes.
page 21,
Page 21, yes, my lord.
at paragraph 22, it says the approach by the Forestry Commission in the notice will undermine the intentions of Bristol City Council to include the land as part of a strategic allocation for a new residential neighbourhood for this part of Bath Road, Brislington. Brackets, the land is part of a wider strategic development location for 715 new homes in the draft Bristol Local Plan Document 6. So I would have thought myself, since that is the objection,
Yes.
that the document that's worth looking at is the document that's referred to. Is that the one that we've just looked at?
Well, I think the answer to that is yes. Hang on, let me just check again. That was the one you were referring to.
Yes.
Yes, the answer is yes.
This is an objection in May 2020, and you're
Yes.
taking us to a March 19.
Exactly. So the answer to that is yes, because there are further iterations of this, but the next one doesn't come till
Yes,
2022.
but I'd just like to understand the status of the
The
document.
status is that
If you'll let me.
I'm sorry, my lord. Sorry.
I think I picked up somewhere, you said this is a consultation draft.
Correct.
This is the first stage in the process set down by the local plan regulations.
Correct.
The Reg 18 draft,
Yes.
I picked up somewhere this was the subject of a second consultation,
Correct.
which was several years later.
2022.
2022, thank you.
And we have
That's
that
still a Regulation 18 draft, is it? Or it's not the Regulation 19 draft, which is put on
That's
deposit
correct.
and gives rise to the objections, which are then examined
Correct, my
in the
lord.
process
So-
going on this year.
Correct. As it happens, there were multiple Regulation 18 drafts. This one in 2019 and a future one.
So this is a very early document.
Correct.
We're a long way away from the Reg 19
Correct.
document.
And here we are in 2025, and it's still being examined at the moment. You know, the Regulation 19 one is being examined at the moment by the Secretary of State. But the point is, my lord's absolutely right. This is it doesn't get any earlier. This is the very first statutory step in the process. And this is not, and it's state what I'm sure is obvious, but this is not an allocation. It's not anything close to an allocation. This is a consult.
Secondly, this
Sorry, my
is a proposal to remove the site from the greenbelt.
Correct.
But it involves amending greenbelt boundaries.
It would.
Is the national policy, as I recollect it, that is done in exceptional circumstances?
Yes, that's right.
That's in the national planning, the NPPF.
Correct, my lord. That's right.
Because what the case seems to be referring to then is paragraph 4.3.28, which explains the text that you've taken us to. It'll be relocated to land near Hicksgate within Bath and Oxley Sunset.
Yes.
This proposal will be at least 750 new homes, which seems to fit with what's said,
Yes.
and that will require what's described as a small change. So
Yes.
this is what we're talking about.
Correct.
Is whether the possibility that's been identified in the consultation document is something that merits the upholding of the objection.
Correct. That's precisely it. It may be said, if we were being hypercritical, that the language that my lord's taken me to at paragraph 22 of the objection, which is on page 21, might slightly, if misinterpreted, perhaps might be slightly overselling the status of the
Yes.
2019.
But I'm trying to anchor this case in what it was.
Well, exactly.
Objection.
Well, so if we just work through what's being said there, the undermine, second line, the intentions of the Bristol
Yep.
City Council, well, maybe, but this was a consultation exercise. You know, it was being thrown open for discussion.
You know, I understand all that. Don't worry
and
about
the-
that. But I'm just trying to remind us that this is not a planning inquiry.
No, no.
This is a consideration
Oh,
of
of
an
course.
objection.
Oh, very much so, my lord. No, certainly don't.
It's all right,
I
so we've got
don't
the
demur from
consultation
that
document now.
for a moment.
Yeah.
Now, that the felling happens in February of 2019. The Forestry Commission's response, the ultimate regulatory step, there's investigations that happen in 2019, but the ultimate regulatory step comes in March 2020. And that is the issuing of a restocking notice. And we see that, of course, already found it, but just to be clear, we see the letter on page 9 of the supplementary bundle. It introduces the notice. And we see the notice itself from page 11 over to 12 and 13. The court will see there's the notice, and then there's on page 11 there's a schedule with a numbered paragraphs underneath the signature of the Forestry Commissioners. And the first point on the schedule is that the restocking has to happen before the 30th of June 2021, so in just over a year, whatever that was, 13 or 14 months or whatever. And it sets out how many trees and all of that need to be, what kind of trees. And then the key point for what comes later is the point at paragraph 4 of this schedule, which is that for a period of 10 years from planting, the trees must be properly protected against damage, etc., etc. So you've got to plant them by a given date, and then you've got to keep them, you've got to maintain them and protect them for a period of 10 years. That was the thing that the respondent was seeking to have amended by the Minister, and I'll come back to why in a moment.
Can I just ask,
Yes.
in the schedule, paragraph 1,
Yes.
the document refers to the felled area outlined in blue.
Yes.
Is that what we see at page 13 of the...
Precisely. That's it. Precisely.
So it's an area just to the southeast of the buildings on the
The
garden.
buildings, exactly. It's the bit it corresponds
Southwest,
with
sorry.
southwest, precisely. It corresponds with the bit that you can see hopefully on the photographs that I showed the court, which goes from being planted to being bare. But yeah, precisely, my lord, that's it.
Thank you.
So that's in March. In May, the respondent appeals against that notice, and this takes us to the series of papers that my Lord Lewis asked about, Lord Justice Lewis asked about earlier on. That starts on page 15, runs through onto page 16, which is where we get the pro forma, and then page 17 and onwards, where we have the supporting statement of case. On that statement of case, there were two grounds set out. Those two grounds are at the top of page 18, are summarised at the top of page 18. The first one is that the felling of trees was not in contravention of the Act. I'm reading from the top of page 18. Just to be clear, that point, or all the points that go along with that are all dead now. So we're not arguing about that anymore. It's accepted in consequence that the felling was in contravention of the Act. Secondly, the second ground is ground 2, and it's really within ground 2 that the points that arise in this appeal are said to fall. Ground 2 is further in the alternative. In respect of such felling that was in contravention of the Act, the requirements of the notice go beyond what's reasonably necessary and are disproportionate. So it was in the context of a submission about reasonable necessity and proportionality that what the points that we're about to come to were being made. So ground 1 we can skip over in the document. Ground 2 starts on page 20 of the bundle, and indeed the relevant bit of ground 2 starts on page 21. Under the heading case for objection on the notice concerning area B, we're told that at paragraph 21, that there's something called a secondary case. Secondary case in respect of area B, skipping over the brackets, is that the schedule for restocking is unreasonable and disproportionate. And then we get paragraph 22 that I've already touched on and that the court's already taken me to, which is key for what comes later. Paragraph 23, the Forestry Commission's position, therefore having regard to all the points about the emerging local plan, etc., consultation, therefore has, quote, public interest consequences. And at 24, paragraph 24, that's expanded on, it is not in the wider public interest. Note this language because it's language that the judge is essentially picking up on in her judgment. It's not in the wider public interest, so it's
You can omit those words, public interest and wider public interest. What he's saying is it's not a good idea to require restocking because if there is going to be development, the development wouldn't be able to take place. That's what
correct.
He's saying.
That's right. That's right.
And that's the issue is how they dealt, how
that
they
was
were
dealt with.
required to, and how they did deal with the objection that it is a ground of objection because it's undesirable to require restocking.
Yes.
If that could potentially prevent the development, and one needs to work through precisely how the objection was put.
Quite, that's what I'm seeking to do,
Yeah.
and I accept all of that, my lord. I don't quite accept that one could omit the words public interest because it was being framed by the objector. The justification given for this point about blight, etc., was because it would be contrary to the so-called wider public interest. But I accept that we've got to work through the objections as it was.
You passed over paragraph 23.
I'm sorry, I didn't. Oh no, I didn't mean to.
Because, sorry, as I understand it, the notice does not prevent development from taking place. When a full planning permission is granted, section 9(4)(d) would apply, but would not apply in relation to the 10-year maintenance period.
Yes.
And that's what this case was all about.
Correct. That's why...
So it's about
correct.
deferment, not impossibility.
Correct. That's right. And that's why...
That's the effect of the Arnold White decision in this court.
Correct. Yes, my lord. That's all absolutely correct. It's not about impossibility. It's about we'd have to wait however many years, not 10 years, but however many years it would be between the grant of planning permission.
Well, because the Court of Appeals decided that the planning permission, when granted, does not annul the maintenance condition.
Correct. Exactly. That's right. That is what this case is about. So, the Forestry Commission issued 2 responses.
Well, hold on.
I'm
We
sorry,
need to. I do think we need to look at the objection.
Yes,
We've
ma'am,
got
of
that in 24, and it goes over. And what it is actually saying is that it shouldn't be done at all. It seems to me the interest of amenity would be best served by considering the future of the land in the planning context,
Yes.
rather than requiring restocking. The argument appears to be: don't restock, let the planning process work, and if they need trees, they'll do it in the planning. That seems to be what that paragraph says.
Yes, there was part of what paragraph it is. Part of what the objection was saying is that don't require restocking at all on this site. Require the restocking to be somewhere else on an alternative.
Yeah, well, I will get to that. And then 26, it says the proportionate and reasonable response is to vary the notice to require the site to regenerate naturally.
That's right. That's
So
right.
it's saying they don't restock at all. And then it goes on to say there wasn't much, that they were only maples anyway, so who cares about them?
Yeah. Well, it's true. I mean, it'd be fair to say the objection was put in. These are all different and mutually inconsistent point. I mean, these are different. These aren't just different versions of the same point. These are all different points. One of them saying that that we should amend so as to allow planning permission to take precedence if and when it's granted. One of them saying, as you've said, my lord, don't just allow it to replant itself naturally over time.
Do we have in here what emerged and was considered by the judge? In other words, that it immediately falls away.
The what? I'm sorry.
Do we have expressed in here what the judge focused on, which is a proviso that the 10 years ends early if full planning?
I don't think.
I don't think we have it in the objection.
I think it
and
comes-
that's why I was coming back to the objection.
I see.
That's the whole point.
I see, my lord.
And I keep saying it's not a planning inquiry, it's a consideration of an objection. And the objection doesn't have, as my lady pointed out, that's where I was hoping we would get to.
I see.
The proposal for the thing being lifted in the event the planning permission is granted.
That comes later.
At this stage, they were saying, don't restock, full stop.
Yes.
It'll stop, or it might stop any development if it's allowed, and any development will take care of the trees. And don't worry anyway, they were only field maple trees and weren't very pretty to look at. That seems to be the objection.
Correct. I mean, I'll let my learned friend speak to it, but correct. The point that my lady's alighted on comes later in the sequence.
Okay, and I can also see, as regards alternative land, that isn't put forward at this.
That comes later too.
Again, this.
Oh, my learned friend's shaking his head.
Well, I was wondering about 32.
Yes, 32 and 33.
Sorry.
Well, exactly, but it says you haven't identified at this stage.
Oh, 32. Yeah.
Alternative land.
Of course. Sorry.
It's a bit
Quite
different.
right. So, yes, the appellant at the end of 33 were told that the appellant was continuing to seek to identify a suitable alternative piece of land, and will place proposals before the committee and the minister as part of this appeal. Yes.
So this was effectively saying, don't use the restocking following an offence provisions, leave it to the planning process. That seems to be the thrust of it.
Yes.
Well, it's certainly the primary proposal.
The primary proposal, it would be, yes, and as my lady's alluded to already, that the proposals change over. We'll come back into how it's being argued by the time of the reference.
It puts forward primarily don't do this at all, but it then puts
Yes, that's right.
floats some
Float some more ideas. Yes, I I adopt that way of reading the letter.
But if we're dealing with whether the committee or the minister erred in not upholding the objections, it is important to look at what the objections were.
Yes. Yes.
Yeah.
With the caveat, I suppose. I mean, I accept all of that. The way that things will be, we have a record of the way things were actually argued before the committee, and the court will see in a minute when we get there, a couple of years on, that the arguments have morphed a little bit. But we'll see that.
Yeah,
We'll see that in a moment. So at the time, however, going back to 2020, in fact, it was some time later, skipping ahead in time, the Forestry Commission's issued 2 responses to the document that we've just been working through. The 2 documents are in fact contemporaneous, even though you wouldn't necessarily know that from the front covers. The first begins on page 31 of the supplementary bundle. The second begins on page 48. The first is called a principal submission to the reference committee, and the second is called a rebuttal to a notice of objection. So, to be clear, both were in fact issued on the same date, and that date was the 17th of May 2023.
In the run-up to the committee hearing.
Thank you. And the reason that was being done then is because the committee hearing that we'll get to in a moment was just around the corner. So this is when the Forestry Commission, as it were, sets out its position. If we just start, I won't spend long in either one, but just to start very briefly with the first, it starts on page 31. The background page on page 32 is important, but we've already looked at it, and it sets out important points of the chronology. Do just note, by the time we get here on page 33, by the time we get to page to May 2023, which is when all of this is happening, we note halfway down on page 33 that in fact there are enforcement proceedings. This is all of the planning regime, or moving back out of forestry. We're told that Bristol City Council have issued an enforcement notice in this area known as Area B because there's been a breach of planning control. And the enforcement notice under the planning regime is requiring all of these different things that are set out between 1 and 4 there, which was itself at that time the subject of an appeal. The legal framework is set out. I'm going to go through the legal framework, but I'll skip over it in this as it's set out in this part of the document. There's a section on planning, which is from page 38. Again, the Forestry Commission starts by setting out some of the legislation, and it goes into the Arnold White case, all of which I'm going to come back to, so I'll skip over.
But it does actually tie it to the objection at the bottom 38.
Yes.
It says the objectors claim the restocking notice will undermine the wider development
Correct.
condition.
Yes, my lord, that's
and then
right.
it says, but in fact, the section 9.4 requirement when you're dealing with selling licenses, not restocking notices, deals with things that are immediately required, not intentions.
That's right. That's all of which essentially represents what I'll be saying in a few minutes.
Yeah.
But no, quite right. So there's a reference to section 9. So this is not, I emphasise, given what happened yesterday, this is not a case where the points were being swept away under the carpet. The points are being addressed by the Forestry Commission, and they're explaining why they don't think they're good points. But it's not, which is a question on for the reference committee and the minister and ultimately the court. But it's not as if no one was talking about them. And then indeed there's a reference on page 39, just after the bit that my lord's just finished reading out, section 9.4. There's a reference to another planning application. So there's quite a complicated matrix of fact that's going on now. In addition to the enforcement proceedings, the planning application in 2021. Which is for a change of use to essentially a builder's yard, to summarise, car sales, different commercial uses, all of which was refused for reasons set out by the planning officer, relied on by the Forestry Commission, including, in the final paragraph in italics, the officer said, that this is the planning officer of the Bristol Council said, in the absence of evidence to the contrary, the development has significant harmful impacts on connectivity and function in the wildlife corridor and ecology.
So what's the relevance of that? You said it with great drama, but how is it helping us?
The relevance is that it is being said as part of the objection that we need to be careful not to flout the intention of Bristol City Council, who are looking to allocate this for housing development. But we have evidence, or the Forestry Commission had, the Reference Committee had evidence of what Bristol Council as a planning authority actually thought.
Yeah, in relation to the use of the land as a scrapyard.
Yeah.
Yeah, that's right.
I don't think it's helping very much.
Fine,
It
moving
sounds
on.
like a jury point.
Yes, it is.
I don't want to make any of those. The rebuttal, that was all I wanted to say about the principal submission. The rebuttal submission...
I'm sure you want to say more, because I'm sure you want to draw our attention to the restocking notice bit. Having said what happens with the planning, when you read through the restocking notice, for example, at page 40, it explains, for example, at the bottom, the purpose of a restocking notice is to replace trees that were unlawfully removed. A restocking notice is not a retrospective felling licence, woodland management plan, or other management tool. It's not designed to facilitate the wishes of the landowner.
Well,
its exclusive function is to... There is an argument as to what the forestry interest is, and I would have thought you might have drawn our attention to it, but you want to go to the next document.
Well, no, I was... Obviously, I endorse and rely on what's said there by the Forestry Commission, but I was going to adduce that as part of an analysis of the statutory framework. But safe to say that the observations of the that the Forestry Commission make in general in this document, but there in particular, on what restocking notices are there for, are absolutely correct. And to be honest, are not really contentious in this court. But we'll come back to it. The purposes that a restocking notice are there to fulfil are there set out in black and white in the statute, and the commentary from the Forestry Commission about not a retrospective felling licence or any other forestry management tool not designed to facilitate the wishes of the landowner are all, in my submission to the court, are unarguably correct. That's absolutely what a restocking notice is there to do, and indeed not to do. Now, the rebuttal submission, which, as I've said, was contemporaneous to the principal submission, is very much of a piece with the principal submission. It parcels out similar points, or the same points really, but it does them it does them one by one in response to claims, as they're called, claims in my learned friend's statement of case. It sets out the claim and then it sets out a point of rebuttal. Note in particular on page 57 of the bundle, claim number 15, as it's numbered, is sets out paragraph 22 that my lord took us to earlier, and the rebuttal thereafter is set out. So this is the claim. The answer that's given is that the Act provides no exemption for the requirement of a felling licence where a strategic plan is in place. So the Forestry Commission considers this claim as irrelevant. Bristol City Council placed an area TPO, tree preservation order, on the site. As soon as they became aware of the felling, indicates they recognise the importance of the trees on the site. And then it goes into the bits of the planning history that I've set out already. The Forestry Commission go on to say, right at the end of this section, before they get to claim 16, that the Forestry Commission therefore conclude that works on the land that have been conducted by the objector have in fact undermined the intentions of the Bristol local plan rather than support it. And that was their position at page 58.
And works required under the restocking notice are to restore the land to its previous condition.
Correct.
What it really seems to be saying is, look, this is an offence regime. You restock if you've committed the offence. You wouldn't get a felling licence or be excused from getting a felling licence because you had a strategic allocation thing in place. So why should you be avoiding the restocking notice? That's what it's really saying.
Correct. That's right. And there is a submissions framed in terms of the public interest on page 59 of this, on the next page, in response to my learned friend's argument about the public interest, etc. There's an analysis from a series of submissions from the Forestry Commission on page 59 to do with why the Forestry Commission considers that in the end the replacement of lost trees is, see the final sentence, highly within the public interest. But yeah, I'm sorry, my lady.
That touches on the development, as it were, of forestry objectives, which are called, we haven't discussed this much, but they have modified over time, haven't they?
They have.
Initially very much from ensuring there was a reserve of timber to
Yes.
actually quite different.
That's right. They've changed, and the senior president touches on that in Arnold White, and we'll come to that in a minute. But that's quite right, my lady. The purpose of this regime, the forestry regime, has developed over time, and I suppose you might say has expanded almost over time from something that was quite discreet to something that's quite.
It doesn't. That development doesn't necessarily fit wholly comfortably within the legislation as drafted.
Let's get to the legislation.
Well, we don't. I don't want to take you out of your turn.
No.
But I can see here a reference to a 25-year plan.
Mm-hmm.
Which, what was that? So that's a direction, is it, to the Forestry Commission as to how it's supposed to discharge its functions?
That is a good question.
Or is it's a broader thing?
I don't know the answer to that question, so I'll take some instructions on it. Well, I'll get to the statutory purposes of the forestry, well, the regime as a whole, but the Commission and their role within that regime are absolutely foundational to my case, so I want to get there as soon as I can. They're critical, but my lady's characterisation of that evolution is right. That's right. It is a regime that has seen a change in its purpose or its scope. Now, the reference committee met on the 19th of May 2023, so that was only 2 days after these documents. And we'll come to their report in a second, obviously. We have summarised in writing what my learned friend told them in a document that is dated June. So the document comes after the meeting. Presumably it was to something he didn't explain, but presumably it was to summarise what he had said and draw together. Oh. Okay.
Well, there's an outline submission of the objector that's dated the 2nd of June at pages 70 to 75.
That's what I was referring
so that
to.
comes, as you say, after the meeting, if the page 76 is accurate, on the 19th of May.
That's what I was.
I suspect that might be.
That's what I was referring to. Was that a typo maybe on the date?
I suspect that might have been generated by the day it was printed. It might have been a macro.
Well, we're not going to have speculation on that. It says
we'll find out.
The 2nd of June, and I'll treat it as the 2nd of June unless we're told it's not the 2nd.
Well, I had. So I mean,
by proper evidence. Yeah.
Yes. So in any event, it was there or thereabouts. It appears to have come afterwards. It doesn't affect my case whether it comes afterwards or on the same day as the meeting. And that summarises what my learned friend either had said or was saying to the committee.
The committee didn't meet in May.
Oh, okay.
Page 90, paragraph 8, a report to the Minister.
I've got that. It's mine.
Paragraph 8, the reference committee met on the 2nd of June. And in effect, those are my skeleton submissions to the committee.
I see. Okay. Well, I appreciate that. Sorry. Then there's another issue with the
sort
date.
that out over the lunch hour.
Thank you.
Yeah.
What's odd is at page 76 we got the date of the 19th of May for the meeting.
Well, that was the date I've been using, but I'll look into that. I'll take some instructions.
By the time it got to day 2 in the Court of Appeal, that basic factual issues like this would have been sorted.
No, I accept that, my lord.
Anyway, we're on page 76.
Yes.
Or are we on page 70? I mean,
We're on page 70 is the beginning of the document, but where I wanted to take the thought was to what is said on. So there's a number of issues adduced by my learned friend. The first issue was all about different separate parcels.
We don't want to go through all of this, but it is not relevant.
No. Issue
Don't waste
3.
more time. Take
issue
us to the bit that's relevant.
Issue 3 on page 73.
Yeah.
This is the issue: was should the requirements of the restocking notice be varied so as to allow the redevelopment of Area B for housing within the next 10 years, if so required, in the public interest. And this is where, years on from the original objection, this is where the point from my learned friend on this is sort of developed. And the nub of it sets out the Arnold White case, sets out what he considers to be the implications of that case, and the nub of it really comes at 22, which is over page
This is the first time they've suggested, as my lady pointed out, a variation of condition to remove it in the event. It wasn't part of the objection.
Correct.
It's a submission to the committee, yeah.
That's correct. So this is where that submission is made. And then issue 4 develops a point that was made, as we've seen in the original.
And the reason for doing it is because there might still at some stage be 500 to 750 houses.
Correct. So issues 3 and 4, though identified as separate issues, no one can appreciate why, they do rest on the shared premise, if you like, which is that changes need to be made of some sort, either a change to one of the conditions on the notice or an alternative site or something needs to happen. Why does it need to happen? It needs to happen because there's a prospect of planning permission happening in the future and we need to accommodate that somehow.
Yeah.
So that was what was said by my learned friend to the committee. We have the report of the committee.
Just sorry,
my
I'm
lord.
being a bit slow, but
No,
issue 4, that's where the alternative site is raised.
Correct, my lord, that's right. That's right. Where it had, in fairness to my learned friend, been raised in the way that it was in the original objection, and now it is.
Well, a site is identified.
Yeah. So it's developed. It's developed. So it was before the. But as I say, although it was developed, the logic of it shares a premise with issue 3, which is that why do we need to do it? Why do we need to think about it? Well, because planning permission is very important, and we need to be careful to not impede it or avoid, facilitating it if it were to happen. So 2 different ways that my learned friend had identified for achieving the same sort of goal, which is to make sure that forestry doesn't get in the way of the planning system. The reference committee considered all of this, and we had.
Well, it's useful to look again.
I'm
so sorry, because
no, I don't
the
want to rush.
decision it will be sent to informed parties.
Yes, my lord.
And it's very useful. If you look at 79, paragraphs 29 and 30,
Let me just get them.
Mr. Richards said, look, you could end up stopping the land being developed if it was removed from the Greenbelt and the housing development was to be allocated there.
That's right.
And he stated that some may argue that this is a consequence the objector must face,
Well,
given that he did not wait for planning permission before felling the trees. Mr. Richards stated that this is not so simple, because the land has in the local plan been allocated to meet housing needs. I don't know whether any of that is correct or not.
that's incorrect.
It's incorrect.
Well, it's not been allocated to meet housing needs. It had been.
That was the premise.
What? Oh. Well, just to, whatever the. So just so it's not misunderstood, the land had and has not been allocated to meet housing needs.
Yeah.
So I don't know. It may be just a slight that he was sort of slightly mistaken in what in the way it's been interpreted. But yeah, as a matter of fact, it's not been allocated.
And if a local development plan was approved, then it would follow the planning permission would be granted. Well, yes, unless there are other material
Well, that's right, my lord.
considerations.
It doesn't. One might say, unfortunately, but that's not the point. It doesn't follow that an allocation takes one automatically to a planning permission. Far from it. Many of the cases that end up troubling this court, or the court below, certainly the planning court, relate to situations where, yes, there's an allocation policy, but you've still got to achieve a planning permission, and all sorts of things can happen.
And he says you can avoid the problem by his paragraph 22 varying the notice.
Yes.
And he says that would be a good solution in his mission, because it would allow restocking, but would allow the trees to be taken down, and that was a better answer than
Correct.
observing the felling regime. Those are the arguments that were being put.
That's
to
right.
local
Sorry. Yes,
reference
absolutely.
committee.
That's right. And that was the argument that was being put to the reference committee. Their approach to that argument appears in their report. Their report is in the core bundle now, so we're moving bundles.
Yeah.
And it's right at the back. It starts on page 217, which is 3 or 4 pages from the back.
Yeah.
Sorry, could you give me the reference again?
Core bundle, my lord. You haven't got tabs in this one either, I anticipate.
No.
Core bundle from page 217.
Thank you.
We have the report. We have the members of the committee, and then the issues are set out in bold. Land being 2 parcels doesn't trouble us. Proportionality of the notice again doesn't actually trouble us. It doesn't relate to the point that's before the court. Issue 3 and indeed issue 4 on page 218 do trouble us. Those are issues on which points are taken. on which the judge found that the minister had erred. So issue 3, paragraph 11 and following. Paragraph 11 says that the reference...
The heading is quite significant.
Yes.
Modifying the restocking notice to accommodate future development.
Quite
Then
right.
11, yes.
No, modifying the restocking notice to accommodate future development.
That's what they were considering.
That was what they were thinking about. So should it be modified to accommodate future development, as my learned friend had suggested? Paragraph 11. The reference committee accept that the land in question may be removed from the green belt and earmarked for development at a future date. The reference committee, however, agreed, and that is to say, well, in my submission agreed with what the Forestry Commission was saying, but in any event, agreed that this did not mean that the felling was exempt from the requirement for a felling licence. And just pausing there, so far so uncontroversial, because that is clearly correct. Paragraph 12, the reference committee considered the objector's suggestion that the restocking notice should be modified to provide for the possibility of felling the restock trees in the event the area is removed from the green belt. The planning permission is obtained to build houses in the area. So this is precisely the point that my Lord Justice Lewis was keen to pick up on in my learned friend's submissions. The reference committee agreed this was not appropriate as it undermined both the felling licence regime and the planning regime with respect to lawful tree felling. Just to pause on that formulation, because the judge below was not at all happy with that formulation, indeed found, I think that the way it was put was essentially irrational. It was certainly not well explained as to why there would be an undermining of both the felling licence regime and the planning regime.
Well, we've looked now at the documents and arguments leading up to it, so it may be that we've got a better understanding.
Maybe.
So what are your submissions on the felling licence
It may be.
and the planning
Well, I'll give my submissions on what that language means,
Yeah.
although my core submission is that it doesn't really matter. And then the judge below said in the end it was a sort of throwaway comment or something akin to a throw. But I'll say why I think that I submit that the formulation's fair. Firstly, as to the felling licence regime, why would that be undermined? The approach urged by my learned friend would have undermined the felling licence regime because it would tacitly sanction unlawful felling. And that is to say, the starting point under the statutory scheme, to which we are going to come very shortly, is that later permissions cannot retrospectively authorise unlawful felling. And the approach urged by my learned friend would flip that on its head, would have flipped that on its head. It would, in effect, assume or invite the Forestry Commission or the reference committee to assume that building out a planning consent is more important than effective forestry control, such that the latter should yield to the former.
Say that again.
I'm sorry, my Lord. The assumption would, in effect, be that building out a planning consent is more important than effective forestry control, such that...
I think I'm having trouble with the words building out a plan.
Achieving development on a site. So, for instance, clearing a site for houses, cutting down trees in order
the
to...
word used in the statute is implementing.
Thank you, my Lord.
Implementing the permission.
If I say implementing a planning permission, for whatever, but for
replicating
houses.
section 9(4)(d).
Yes, exactly. Implementing a planning permission, the assumption would be, is more important than effective forestry control, such that the latter should yield to the former.
Hold on, you're going very quickly.
Don't mean
The
to
assumption
be.
would be
Implementing
a more important than...
Effective forestry control, such that the latter should yield to the former. Now,
But it goes further than that, doesn't it?
my lady,
It goes further than that, doesn't it? Because it potentially puts the unlawful fella in a better position than if they had done what happened in Odd or White.
yes, it does, not least because when the issue comes before, say, a planning committee down the line, I mean, it's not this case, but if and when it came before a planning committee, the status quo on the ground would be one in which either there are no trees at all, or in which there are some trees, but they're very young, they're whips or have only just been planted. The ecological or arboricultural interest associated with either those young trees or the lack of trees at all would be very different. to a situation in which there's a developed woodland. And so the merits of the planning determination are would be different.
Absolutely.
And so that's quite right.
Yes, I think even I'm not a planner by any means, but it would make sense that if you went and sought planning permission in respect of an area where there were lots of mature trees, you might have a harder job.
Well, that's right, and that's a point that the senior president, I can't remember whether it's in the judgment or not, but it's certainly a comment that the senior president made during Arnold White, the approach, doing this in effect the wrong way round, which is to say, I use that just in shorthand, the right way round is to get a planning consent and use that planning consent to cut down.
But the point is, getting a planning consent with mature trees may be harder.
Yes, that's right.
That's looking at the application of the planning regime. My lady's question started off with the forestry regime, and she was putting to you that the argument that was being presented to the minister here would put the landowner in a better position. And if I follow correctly, it does, because the condition, the modified condition, if accepted, would remove the delay otherwise attributable to the 10-year maintenance period.
Correct, absolutely.
It would disapply the ruling of this court in Arnold.
Well, that's my submission, yes. That was not accepted by the learned judge, but yes, that is precisely right. It's an excellent outcome for the developer of the land, because they have essentially succeeded on my learned friend's approach at circumventing forestry control full stop.
But hold on a moment there. Arnold White, the arguments as I understand it around paragraph 74, that if trees weren't, if there wasn't a restocking notice or a requirement there to the felling notice rather than the restocking notice, if there wasn't a requirement to put trees at all, then you're better off because you're going to the planning committee, you've got a site with no trees. This is not quite that, because there will be trees.
That's right.
It's just that they can be felled.
Yes.
But there are two things about that. As my lady says, there's a difference between mature trees and non-mature trees.
Yes.
And in a sense, it's still the wrong way around, and you shouldn't sanction that, although they say, well, it's happened and therefore live with it. So that's a slightly different version of it. Mm-hmm. But that's the issue, really, isn't it?
Well, yes, but my lord's making the additional point
about
that if the respondent's position is right, you do get round the 10-year.
You get around the 10-year and the felling thing, because it's an automatic. You import 9.4 effectively.
You import. Well, that was the intention. That was the intention was to import.
You're not importing section 9.4. You're using the same words, but the way it operates is different.
That's right.
If you comply with the law and do not jump the gun by felling trees before you've got either a felling license or a full planning permission, then there's a period of delay.
That's right.
Built in. Because you have to wait until you've got the full planning permission. That's the way the statute's phrased.
Yeah.
But if, on the other hand, you replicate that language in a condition such as this, you overcome the Arnold decision, which says that getting a full planning permission, if you jump the gun,
that's right,
doesn't annul the 10-year maintenance period.
Quite. And that is why, I mean, I'll come on to Arnold White, but I was very much submitting below that this approach was inconsistent with what the senior president had held to be the situation in Arnold White, and obviously the judge below was totally unpersuaded by that for reasons that I'll come to.
Can I just go back to this, and it's my fault for being slow.
No, my lord.
There are two things, felling license regime and planning regime.
Yes.
Now, I understand the felling regime argument. You're focused on the sanction for unlawful felling is a restocking notice, by and large. And you're going to get around that if you don't have such notices, and that's been put in the arguments. And then you develop that. The 10-year maintenance being circumvented, that seems to me to go more to the felling license regime than the planning regime.
That is fair. Yeah. I think that
is fair. So when we're looking at, because I'm wondering whether the judge was right to say that it is irrational about the planning regime. The difference with the planning regime, or the point about the planning regime being in inverted commas, undermined, is to do with the mature trees, isn't it? That is the thing that you say is...
Yes, there are two things I say. So I would accept that the undermining applies more neatly to the felling regime than it does to the the forestry regime, than it does to the planning regime. But I do nonetheless say that there is undermining going on of the planning regime as well.
Yes.
And there are two components to it. The first is the point that my lady's been developing to do with the
mature trees,
mature trees point. But there is another point.
Yes.
The justification, the putative justification for my learned friend's modification of the condition, the putative justification is predicated on an alleged prospect of achieving planning consent. That's the reason that we're having this conversation at all. The reason he's making this objection is because he predicates it on the alleged prospect of achieving a planning consent at some point in the future. And the undermining, maybe undermining is not quite the right word, but the undermining is that, of course, the planning system has yet to even consider the extent to which, if at all, that may or may not end up being correct. And that issue is not one that the Forestry Commission, or certainly the Reference Committee, is in a position to reach any sort of judgment on at all, either legally or indeed institutionally, given its composition.
But we're looking at the wording of the Reference Committee report.
Yes,
and I think you've gone away from that, because one of the criticisms on ground one is to do with words used in that paragraph, and it says the Reference Committee agreed that it was not appropriate, i.e. modifying it so that the trees could be removed. And remind both the felling licence regime, we've gone through that, and planning regime with respect to lawful tree felling. And what I'm trying to work out, because I'm not the decision maker, thank goodness, I'm trying to do a much more humble job, which is to read the words on the page and see what they mean. So I'm trying to get you desperately to focus on the phrase planning regime with respect to lawful tree felling. What was it that they meant there, that they had in mind? Because it can't be this achieving planning development is still uncertain. It's something else that they're getting at. Well, and it does look as if it's what my lady was saying.
Yes, it does.
That it's to do with, you're supposed to have a planning permission application dealt with the mature trees.
Correct.
And if you get around it in this way, you're having a planning application in a different physical universe.
Yes, and that is my submission as to its primary meaning.
So it's one, not two, then. Your second point about the alleged possibility isn't relevant.
It's supporting or trying to deter the undermining the planning regime is indirectly that planning should be taking place in a sort of lawful universe against the background that the trees have not been unlawfully felled.
Yes.
And that in itself might affect planning.
That is absolutely right. Yes.
This was a case where development was proposed and a listed building had been knocked down. You might expect a listed building enforcement notice to require it to be put back up rather than determine the planning merits on the supposition that the building isn't there.
It is a direct analogy to that. It's a direct analogy to that. So,
because otherwise it just encourages people to knock down listed buildings and cut down trees.
Yes.
Because when you read the background that we've had and you read the opening sentence, it should be modified to provide for the possibility of felling the restocked trees in the event that the area is removed from the green belt and planning permission is obtained. Then it makes more sense to say, yes, the planning regime is undermined with respect to lawful tree felling, because you're doing it the wrong way round.
You're doing it the wrong way round. And that,
to
that extent, there is, as I'll come to, a direct analogy with what this court was considering in the Arnold White case, because that was also, I appreciate, slightly different nook of the statute, but the fundamental problem, doing it the wrong way round, as it were, was exactly what the senior president had in mind.
But you haven't appealed that point.
To which I will come. Now, that's 12. And 13 is the reference committee considered the argument that the prospect of housing development on the land is in the public interest. So this is the reference committee considering my learned friend's point about public interest. But they considered the maintenance of felling licence regime and the replacement of lost canopy over cover is also in the public interest. That's obviously accepting the position set out by the Forestry Commission in the representations I've shown in the court. The Reference Committee agreed, and again this time it's agreed with the Forestry Commission, they agreed that their remit is not to establish which of these public interests should take precedence, but rather whether a restocking notice is a reasonable and proportionate action in response to an act of illegal felling. And again, I say that operates on a correct understanding of the statutory regime. There's not some sort of broad inchoate power or duty, still less a duty, on the Reference Committee or the Minister to say, okay, right, well, there's different public interests at play here, including under the planning regime. Which one do I like more? Which one do I think trumps? Because that exercise of balancing these competing public interests is precisely what Parliament has undertaken through the statutory scheme that we're going to come to in a moment. The interaction between the two, which should yield to the other and when, all of that, it's all been considered in a carefully constructed statutory scheme.
Would you, just trying to understand that a bit
Of course.
Would you say that, in a sense, the right place to consider these balancing items, these balancing issues between ecology and development and so on, is the planning regime? Because I'm just going back to this, we shouldn't have unlawful felling, and what you should do first is get your planning permission. And the process of that, as I understand it, requires all sorts of factors to be taken into account, which would include
the loss of trees.
Tree preservation.
That's right. The planning, yes. So the planning, yes.
So there is a balancing at some.
That's right.
In one regime.
That's right.
Least, the planning regime.
That's sorry. That's absolutely correct. The planning regime is broad enough to encompass lots of different interests, like those of ecology and forestry, and also development. And it's through, in particular, Section 9.4, but other places too, but in particular Section 9.4, that Parliament has decided that balance has to happen first before we get anywhere near that. That is the place that these things are balanced. And if it is found that the interests of trees, to put it shortly, must yield to a wider public interest in the delivery of housing in the circumstances of a particular case, that's got to happen through the planning regime, and there it follows that the licensing regime doesn't bite in such circumstances because the planning regime has thought about it all together.
Well, hold on, just to take that in two stages,
yes,
because this is potentially much more important than the facts of this case.
Yes.
Your submission now appears to be that it would be unlawful, in effect, to uphold the objection where, in circumstances where something short of a full planning permission involving the removal of trees have been granted. Let me put it a different way to make it easier. Mm-hmm. Would it have been unlawful for the reference committee to say, on balance, we agree with the objectors. Yes, he was wrong. He shouldn't have felled the trees. But housing's quite a good idea. We do believe it's coming soon. We don't think there's any purpose in keeping the key trees there. We are therefore going to modify. So would it be lawful, first of all, for them to do that? Because you seem to be suggesting it wouldn't be lawful.
My submission is that it would not be. And the reason for that is because when we get to the statutory purposes and the duties that apply to the Forestry Commission and the Reference Committee, they are specific and they are clear, and those things that are material to a decision under this part of the regulatory framework in the Forestry Act do not relate to, do not bear on, have nothing to do with a potential future prospect for housing or for planning. So yes, it would be an immaterial thing for them to
it's something they cannot consider.
Correct.
Where there's a planning permission, that solves it, but when there's no planning permission, the prospect, no matter how desirable or how imminent, doesn't provide a justification for not upholding restocking notice.
And just to take that a step on and to try and appreciate why that not just is right on my submission as a matter of statutory construction, but also the right outcome all around, is because these proceedings under the Forestry Act, they are not planning proceedings. They are not. They have no statutory relationship to that. We'll come on to the statutory relationship in a minute. these reference committees are comprised of, as I think my learned friend Mr. Green said yesterday, tree people. I think he meant by that arboricultural specialists. Their interest is in forestry and forestation and trees. If you're making a submission to a panel such as this or a committee such as this along the lines of, well, we're sure to get planning consent in the future, how on earth, even if they could, which I said they can't, would they be institutionally capable of adjudicating on such a prospect? They can't, and indeed, for reasons that I'll come on to, the statute doesn't expect them to. But so, to answer my Lord's question, that is my submission.
Yeah. So let me just test it by one further example. The committee resolves to grant conditional planning permission, conditional on a Section 106 agreement.
The planning committee, yes, of course, yes.
The planning agreement has been agreed. It was about to be signed on the 1st of June, but unfortunately the chief executive had a heart attack and they won't be out of hospital until the 15th of June. But once he's out, he'll sign the Section 106 agreement, and the Director of Planning in the authority said, yep, once he's out, once he's signed the agreement and he's going to, we'll issue the planning notice. But it won't be for 2 weeks yet. Is your answer the same? Because the planning permission has not yet been issued, for reasons, and I've done it deliberately, unconnected with planning.
Planning, yes.
That it would be unlawful not to uphold the restocking notice.
That is my submission,
Yep.
and it flows from an analysis of the statutory provisions.
Yep.
So it is to that extent. My submission is it's a binary, regardless of the fact pattern. And I'm going to get on to why in a moment. But I do rely principally on, just so the court knows where I'm going, section 1 and it's section 17 A and B of the Forestry Act to adduce my submissions on what those purposes are and what they aren't.
So the only thing that could affect matters would be a full planning permission, and even that wouldn't do away with the 10-year condition, would it?
No, it wouldn't.
No, it wouldn't.
The only way of solving the conundrum, as it were, is to do things in the way that the legislation's anticipated they be, do things in the right order. The conundrum is not one of the legislation's making. It's one that occurs when a developer tries to do things the wrong way around.
Yeah.
If the developer does things the right way around, everything works, as the senior president said, in perfect synchronicity. One thing follows from the next.
Yeah.
There's no problem.
Let's not forget, Arnold White was a case of lawful felling.
Yeah.
So you're doing things the right way round, but lawfully.
Yes.
Whereas here we've got an added thing that you're not only doing things the wrong way round, your start of the process is unlawful felling.
That's right. If things are done in the proper order, there are no testing fact pattern hypotheticals to consider, because the statutory machinery and works perfect, and that is why.
You think it's a self-contained code?
Well, absolutely, it's a self-contained code, my lord, as the senior president observed. And I do just reflect on the fact that there have, of course, been umpteen hundreds, maybe thousands, of decisions of this court below, on the planning regime since the 1940s and onwards. There have been very, very few decisions, other than Arnold White and maybe one or two more, but on the forestry regime, this will be the second or third major decision. And the reason for that is because normally these fact patterns don't arise, and the reason for that is that if things are done the right way around, there's nothing to adjudicate on, as it were. The statutory framework works. It's not broken. It's only broken if people try and do it out of turn. Yeah. No, that was that.
Sorry, the last question, I think then, if you were wrong on that,
yes,
say it was open to the reference committee and the minister to say, well, he shouldn't have done it, but in fact it's not the end of the world,
yes,
and we will vary the notice. Say they could have done that. That was what they were asking for by the stage of the meeting. If they could do it, have they erred in law by saying they can't decide which should take precedence? Because they've got an objection, please do it.
Yeah.
On this hypothesis, they could do it, And what they say is
They can't. I think
their remit is not to establish which.
I would have to, with some trepidation, I think I'd have to accept that because they're making a comment at the final paragraph of 13 about their remit, and their remit is a sort of it's an expression almost of an understanding of V-rays, and
they're saying we can't.
And they're saying we can't. And if it is this court's view that in fact they can, then they've got their remit wrong, and it's their role to reach an adjudication on which so-called public interest should prevail. So I think I would have to accept that. Obviously, it's not my primary case.
And having said it was the last question, I obviously lied because I've now thought of another one. Are paragraphs 12 and 13 different reasons for the same conclusion, or are they dealing with different points? 12 is the modification of the planning permit, of the notice by saying if you get planning permission, the 10 years goes. And they seem to have said, no, we don't agree with that for the reasons we've already canvassed. Is 13 another reflection of that, or is it something quite different?
It's a reflection of that in as much as the justification that the objector was offering for 12, for the point that was being dealt with at 12, rested on 13. The reason that we were being told to get into modification and then alternative areas, which is the next thing that comes at section 4, the reason that sits behind all of that is because of my learned friend's core proposition, which is that it's the reference committee's job, the minister's job, to decide which trumps, essentially, which interest should take precedence. So
I was wondering whether 13, this is why I made you tortuously go through the arguments, is whether 13 is aimed at a different part of the argument. Don't restock at all, leave it rewild naturally, a la archers, if anyone is in archers. Yesterday it was Rachel Compton and Just William. I have a very simple one. But is 13 aiming at the don't restock, don't just let it grow naturally? That's it. And that's what that is dealing with. And 12 was dealing with the more refined submission. I'm trying to understand what
I appreciate that point, my lord. I've not approached 13 in that way myself. I've not understood it in that way so far. It's certainly capable of encompassing an answer to that submission that my learned friend were making. But I do say that fundamentally what it's there to do is to respond to the contention that sat behind really all of my learned friend's submissions on this point, which is that the reference committee's remit does include one of making a decision as to which public interest is more important.
Yeah, because 12, if you read the whole of it, is talking about modified to provide for the possibility of felling the restocked trees in the event that the area is removed from the green belt. That does seem to be the modifying condition 4 argument.
Yes.
And 13 is the argument that the prospect of housing is in the public interest, which seems to be rather different.
Yes, I do.
So I wondered whether, it's just trying to work out what they mean by. I mean, it may be that they mean that they're aimed at different arguments.
It may be.
Yeah. But you say it's right on 12 and right on 13.
I do. And issue 4 it is all dealt with on 14, 15 and 16. Is to do with the alternative areas. The court will note there's 15 accepted that restocked trees could be lawfully removed either through a felling licence or if specifically identified in a full permission. The reference committee accepted that the area may become available for development before this expiration date, that's the 10 years. The reference committee did not, however, accept that this, and that is to say the potential availability for development referred to in the previous sentence, that this provided a silvicultural justification that the area is ill-suited to restocking, agreeing that any such impediment would have to present an immediate obstacle to the prospect of tree planting. And then at 16, whilst there was by this stage, as my ladies pointed out, an alternative area proposed, the reference committee's view was little or no evidence on suitability and similarity.
Yeah.
All of that, there's the conclusion section on the next page. It essentially, as you'd expect, recaps and says more or less the same thing. In particular, note 20, paragraph 20, the reference committee concluded that while competing claims about public interest were made, these bore no material impact on the appropriateness of the 10-year maintenance period. stipulated the reference committee considered this period, the 10-year period, appropriate, and modifying the notice to allow felling for the sake of potential development would undermine the forestry and planning regulations around tree felling. So that is my submission, a way of essentially saying the same thing that's being said at both 12 and 13 above. And that's that.
Well, 21 says the current area is suitable and no other area has been demonstrated.
That's right. And there is this focus on silvicultural considerations, and for reasons I'll come to when we get to the statute, which I will do, I keep promising to, but we will do. That was exactly the right thing for the reference committee to be focusing on. That is a shorthand for all the things that their statutory purposes denote and relate to and comprise. They were focusing on the right things, not the wrong things. Now, that's their report. That report is then put to the minister. That is put to the minister, and I have to go through this because of the cross appeal that's against me in relation to ground 4.
Yeah.
That's put to the minister back in the supplementary bundle, and the sequence begins on page 87. From page 87, there ensues a sequence. So we have an email first from the secretary to the reference committee, somebody called Mark Curry, who is making a recommendation and a submission for the attention of the minister. This is on the 28th of September 2023.
So who is Billy Green? He's somebody in the minister's
Correct,
team,
that's
yeah.
right.
No.
Oh, is it not?
He's the secretary of the committee.
No, Mark Curry's secretary.
Yeah,
Yeah, that's what I said.
No, it's Billy Green, I asked.
The recipient
sorry.
of the email.
It says, Dear Billy Green,
Sorry, yes.
and I'd like to meet Billy. Who is he?
I'm sure. He's in the minister's
He's
office.
in the minister's team, is he right?
That's right. So that's the email. The court will see that there's a number of annexes in bold that are set out as being annexed to the email. They include, of course, the reference committee report, which is the key thing. There's also a submission to the minister that Mr. Curry sets out in more detail, and this starts on page 89 of the bundle. It's all relatively self-explanatory, but I do need to show the court a couple of contentious phrases that emerge.
Why is he doing this? What's his business?
He's the secretary.
No, I know, but I mean, he's not given the role under the statute. It goes to the reference committee and they made a report.
He's a civil servant whose job is to make recommendations to the minister, as is common, as the court will be aware, is common practice in the civil service. I mean, ministers are given recommendations, summarised, briefing notes, submissions
But
all the
this
time.
is the secretary to the committee.
That's right.
There is a statutory process whereby somebody can make an objection, the minister refers it to the reference committee, there's a right to attend and make representations to the reference committee. They've set out their report.
Yes.
Why is some other person sending out his views as well? What business is it of his?
His business, such as it is to draw this to the minister's attention.
I don't mind him sending it.
He makes a recommendation. I mean, it's a common function of civil servants to
Not a civil servant. He's an employee of the Forestry Commission, presumably, or who's the reference committee then? Or is the reference committee the Secretary of State as well?
Good question. He is. He's employed by the Forestry Commission, so that's right.
So he's not a civil servant then of the minister. So why is somebody employed by somebody else sticking their oar in?
There's no answer to that. And that's not that I have no instructions as to the administrative arrangements that have led to Mark Curry being
Then
the
you
person
shouldn't
who
make
sends
submission
the
saying that he's a civil servant.
I'd understood that
Yeah.
was the
But
situation.
he's not a civil servant. He's somebody who has made additional submissions which weren't.
Well, he is. I've just been told he is a civil servant. He's employed.
He's not a ministerial civil servant.
He's not in the minister's office.
Of the
That's
environment.
right.
He'd be in the civil service. Yeah.
He's a civil servant, but he's not in the minister's office.
And it's not his duty to give advice to the minister, and indeed it's not
No.
provided for under the objections, and it looks unfair to the outsider that he's making submissions when they know nothing about it, and they've gone to the thing, they've heard the Forestry Commission, and then he's writing saying, go with them, Minister.
Well, that's the case.
All he needs to do is send the report.
Yes.
Now, did it make any difference is another question.
Exactly. No, I appreciate that, my lord.
Perhaps you ought to think about stopping it.
Well, indeed. Well, obviously, whatever judgment this court provides on this point will no doubt be useful.
There is a cross appeal on it, a respondent's notice on it.
Oh. All right. Yeah, that's very. Thank you, my lord. Yeah, as to whether it would have made any difference if we had just sent an email that says here's the report. There's the recommendation at 4, which is what I suppose you might have said unsurprisingly that the reference committee's recommendations are accepted. At 5 to 8 and indeed.
What, I mean, even that is odd.
No,
You've got a statutory provision saying you have the reference committee look at it. Why is he sticking his oar and saying, go with the reference committee, they're good people, it's nothing to do with him.
That's a good point.
Anyway.
Point taken. I suppose my submission needs really to focus on whether or not on the facts of this case this would have made any difference. And so the key paragraphs that are held up against me on that, I won't read it, obviously the court can read it, but the key paragraphs that are held up against me by my learned friend are 11 and 17. So most of what happens really is just an elucidation of facts and dates and a summary of what's in the reference committee's report, none of which really could be said to be contentious. But 11 says, it would be most unusual for ministers to reject the conclusions and recommendations of the committee. I'm not aware of any reason why the committee's recommendation should not be accepted in full in this case. And 17 says, that's the first paragraph, 11, that's held against me. The other is 17. Enforcement processes are an essential element of the protection of our trees and woodlands, and there's been a strong commitment to this, and this could be undermined if the recommendations of the committee are not followed. So it's pretty clear where Mr. Curry stands, obviously. My submission on those paragraphs is, well, there's two things. Firstly, it didn't make and wouldn't have made
Well, we
any
need to
difference.
see the decision letter of the minister. If she says, I fully agree with Mr. Curry, what a splendid man he is, then it has made a difference.
Okay. I will show the court the decision letter then. The decision letter comes in the call bundle.
Yeah.
On page 215. It is reported to the respondent in this case by Mr. Curry.
I don't mind him acting as a go-between. He's got to have a job to do.
Page 215, 7th of November 2023.
Do you have anything from the minister at all?
Oh, not directly, no.
I thought there was a letter, but it's this letter, is it?
We do we? 214. Sorry, we've got. Let me just pass.
Well, it's page 214.
214. Sorry. The 2.
Oh, Busy Green again, yes.
There we are. Yeah. So the on page
Private secretary, yes.
214. It's Billy Green, exactly. Sorry. Yeah, the private secretary confirms that the following cases have been cleared and is content for you to proceed. You being Mark Curry again.
So that's the extent of the ministerial decision on an objection.
Yes. Well, yes. Yeah, that's correct. The letter that follows is 215 to 216.
Looking at 2 and 4, did she agree with Mr. Curry or not? We don't know, do we?
Agree with, well, Mr. Curry made a recommendation.
No, my lord is asking about paragraphs 11 and 17.
Yeah.
Those paragraphs aren't specifically alluded to one way or the other.
Yep.
And page 215 sets out the letter. The decision.
Where does the first sentence of the second paragraph come from? How does he know that it was the conclusions of the reference committee rather than his own submissions?
Well, I'd say the conclusions of the reference committee, his recommendation was that the reference committee's conclusions be upheld for the reasons in their report.
Yeah,
so, I mean,
he says it's my duty to inform you that the Minister has decided to uphold the notice based on the conclusions of the reference committee. How does he know that? From the documents you've seen us? Or is there something else? Has he telephoned the Minister or Billy, and Billy's told him?
The only way of getting to the answer that's set out in that letter is by inference. And the inference is that he's put before the Minister a recommendation that the reference committee's conclusions be upheld. The Minister has cleared that recommendation, and so it follows that the Minister is accepting that that the decision should be upheld for the reasons given by the reference committee. But that's the extent of the paper trail.
I think we saw a letter like this yesterday in the first case.
That's right.
Would you like me to help?
I'm sorry?
Would you like me to help now?
Yeah.
If you go back to the supplementary bundle at page 87.
Right. In administrative cases, people never look at facts. They always think it's the law and its principles. But facts are always very interesting. 87, yeah.
You can see that the email said that there's a number of documents I'm sending with this email, the last of which was called Draft Letter to Object.
Oh, okay, yes.
And it's a draft letter of the letter that is on page 215 in the call book.
Okay, so there is a proper paper trail.
Yeah, I don't want to take a point.
No, well, you're being
I was sitting there rather enjoying the
yeah.
the dialogue.
So the draft letter assumes...
But I knew the answer to it.
Yeah.
So my learned friend didn't.
So Mr. Simons, your client sent this letter at page 215 in draft form. No, that's not true. It's not your client. You're not the Forestry Commission. The Forestry Commission sent this draft letter, and then the Minister approved it.
Correct.
That's correct.
So the draft letter assumes that she doesn't pay any attention to paragraphs 11 and 17.
Yeah.
It might be said that that's correct.
Waste of time writing.
Well, yes. It might be said
It's
that
a
that's correct. The draft letter says, for the reasons in the reference committee's report, the Minister's approved that draft letter, and here we are.
There's a lot of things that seem to be going wrong with these procedures. We're treating it as planning inquiries, we're treating it as general administrative decisions. There is a statutory process.
Yes.
Parliament has decided, and governments are subject to Parliament. They don't do what they like in this country. They do what the law says, and the law is Parliament. Parliament says there's an objection. It goes to committee, which is meant to be independent, and then the Minister should decide, and she should give her reasons.
Yes.
And the way it's being done is not of the highest standards of the civil service, if you don't mind me saying so.
My Lord,
and it would have helped us if we not have to spend a couple of hours trying to get to the bottom of this. But anyway, we are where we are.
My Lord, just for the court's information, since Arnold White, which was the first time that a lot of these processes have really been put under judicial scrutiny, their procedures are on the road towards being improved.
Awful.
But yeah, anyway, but yes, your point's obviously been heard by lots of civil servants who are sitting behind me. That's that. That's the full fact set, and that leads to the decision letter that you've seen. I'm not going to spend long in the judgment,
Right.
but just if I can very briefly touch on what was said and what's given rise to the appeal. So we have the judgment in the core bundle. It begins at page 65. It's because of the sort of the multi-party nature of it. I'll just go straight to the conclusions on SMAR because we've done all the facts. The SMAR conclusions start on page 107.
Yeah.
Um, 107, just above G, 169 and following. The first point at 169 is about undermining the planning regime, which is obviously something that the courts we've canvassed already. 169 and 170 is the judge's conclusions on that. But she says at 171 over the page, having found that was an irrational thing to say, which obviously don't accept, but in any event, having found it was irrational, she says that it was something of a throwaway line, not central to the committee's reasoning, highly likely that would have remained the same. My submission is that in fact it was perfectly sound. But
in fact, you haven't appealed that, as Mr. Richards
that's
pointed
correct.
out.
But that's not. I don't need to because her findings on section 31. The bit that I've appealed really turns on paragraph 172. Ground 2 is effectively the same as Witham Nelson Ground 3, and this is it. The Minister erred by not taking into consideration the public interest in the delivery of housing, and therefore the effect of frustrating that delivery by upholding an unamended restocking notice. For the reasons set out above, and I'm just going to show the court what the judge meant by the reasons set out above. For the reasons set out above, I consider this is capable of being a material consideration. SMAR were proposing a mechanism, etc., etc. This is an argument that should have been considered on its merits, not simply dismissed because there was no act of God which would have prevented restocking on the original land. The Minister's failure at 173 to address these arguments was an error of law. So it's 172 and 173 that really is the nub of it. Ground 4 is the procedural ground that I've just alighted on, and it's because of what the judge had found on grounds 2 and 3. She found in favour of my learned friend. She did not go on to determine ground 4, though she does obviously make some comments about the concerning role of Mr. Curry that my Lord Justice Lewis has picked up on today.
We should just note, though, slowing down slightly,
sorry.
in 172 line 6, in this case, SMAR were proposing a mechanism to keep the RSN in place and
Yes.
to be met unless until. That's eliding, that's overlooking the acceleration point.
Yes, that's correct.
And then after the semicolon, all that the RSN should be modified to refer to alternative land, that's actually moving on to ground 3.
Correct. The judge dealt with grounds 2 and 3
in the same sentence.
Well, I was going to say the same paragraph, but it is the same. It is the same sentence.
Yeah,
that's
but
right.
you have to read it. You have to really slow down to see that there are two
Well,
separate points.
that's right. That's right. That's right.
Because
And they did deal, didn't I mean, I thought the Browns Committee did deal both with the suitability of the current land and the fact that the alternative sites had not been demonstrated to be suitable. So I don't...
They did deal with those. I mean, we've
You
seen
haven't
that they
appealed
dealt with
that
them.
either, have you?
I'm sorry?
You haven't appealed that either.
No,
can we just read on in this paragraph? This is an argument that should have been considered, not simply the act of God point. Again, goes to ground 3, doesn't it?
That's right. So,
and then in 173, she says that there's an error of law in each of grounds.
2 and 3.
Including
That's
3.
right.
3 is not impugned. You've not appealed ground 3, have you? In this court?
The point that I've appealed on in my submission picks up 2 and 3, and the reason that I say that, it's a point that I've tried to trail already, is that both grounds 2 and 3 rest on a shared premise. I think the way that the judge analysed it, they do, which is that there is a so-called general public interest in the delivery of housing.
So that taints 3.
Yes, I intended to appeal, and indeed I think we have appealed, in respect of that finding, that there's a general public interest in the delivery of housing. It taints both 2 and 3. And the reason 2 is obvious, I think, I don't need to say any more about why it taints 2. It is a finding on 2. But the reason it taints 3 is because were it not for the so-called general public interest in the delivery of housing, there's no need. We don't need to be thinking about alternative land at all. The only reason that was the alternative site argument was being made by my learned friend was because, as I've submitted already, of the putative threat of blighting a future planning permission. So it does go back to the same thing.
The proposal for alternative land
yes.
was made in the context of the use of the original land for building.
That's right, which is why I actually make no criticism
It's the basis of it.
It's the basis of it, that's the whole point. So that's why I make no criticism of the judge. I do make criticism of the judge, but not for dealing with grounds 2 and 3 in the same paragraph, because in my submission they do flow from the same premise. And the premise is wrong, and the incorrectness of the premise affects both grounds. I did just say that I would note when the judge says, for the reasons set out above,
we need to look at that.
I understand she's doing is referring back to what she'd said about Witham Nelson, which is not a case that's before this court.
No, so she hasn't appealed that way.
Yeah, there are reasons why. but
Well, don't tell
don't need to go into it. She sets out her conclusions that are material and referred to at 166 of the judgment on page 107.
Yeah.
And she, at 166 of the judgment, she makes the point here too. She cross-refers back to what she's about to say later about SMAR. She says that Arnold White, at 166, second sentence, she says Arnold White, that we're going to come to, sets out that the planning regime does not take precedence over the Forestry Act regime. These two are intended to work together. So far, so good. However, that does not mean, and the Court of Appeal did not hold, that when making a forestry decision, the broad public interest in delivering development may not be a material consideration. For reasons that I've touched on, but I'm going to develop more in a moment, I'd say that if that's what her finding on her conclusion on the legal position, that is wrong. So I do say that the statutory framework is such that the forestry regime cannot have regard to the so-called broad public interest in delivering development. That really is the nub of our appeal. In my view, the judge says, it's not a mandatory consideration in every case, but it may be relevant on the facts of this case, and it was necessarily relevant here, given the findings about the inevitability of trees being removed, and therefore the limited silvicultural purpose of simply delaying the development. That's what the court said. So the court's saying there, as I understand it, well, that's the Witham-Nelson, but it's the same conclusion that applies later. Not only could it have been relevant, it had necessarily to be relevant and to be addressed. So that was all I wanted to touch on in terms of the judgment before I turn to the Act, which is where I'd like to take the court next. The Act. So we're turning now to the bundle of authorities. I think it's the same bundle between the two appeals.
Well, there's two different. There's the joint bundle, which is slimmer, and then there's the Wickford bundle, which is bigger.
Oh, I see.
So,
it's the joint one I want. Sorry,
yeah.
It's the joint one.
Yeah.
And again, I don't know if this is tabbed or not, but I'll just give the court page numbers. So the Forestry Act. Forestry Act, page 2. I'll try and skip over all the bits you saw yesterday. Page 2, section 1, the Forestry Commission. The Commission is obviously introduced by section 1. Well, it's not introduced, but it's referred to there at 1.1 as the Commissioners. It's said that it shall continue in its existence. And the appropriate forestry authority, 1A, so far as England goes, is the Commissioners. It's in particular 2, 3 and 3A that are of value for the submissions I need to make. So 2, section 1, subsection 2. Section 1, subsection 2, the appropriate forestry authority shall be charged with the general duty of promoting the interests of forestry, the development of afforestation, and the production and supply of timber and other forest products. That's the general duty. That's what the Forestry Commission is for. And subsection 3 develops that general duty. It is said to include the promotion and establishment and maintenance in England and Wales of adequate reserves of growing trees. Subsection 3, capital A, sets the Forestry Commission the task of achieving a reasonable balance. So in discharging their functions, they must, so far as may be consistent with the proper discharge of those functions, endeavour to achieve a reasonable balance between two different things. Little a, the development of afforestation, management of trees, production and supply of timber, that's the first. And the second, the conservation and enhancement of natural beauty and conservation of flora, fauna and geological and physiographical features of special interest. So just to pause very briefly there, in answer to one of my lady's comments earlier on, it's here that we start to see this multi-pronged function, if you like.
And if I've understood the footnote, historically that was introduced in 1985.
Yes, that's right. So we see that it goes much further than the traditional maintenance of tree stock, as it were. Now, that's the nub of it, and that's the core of what the Forestry Commission have to do. Section 8, capital A, which is on page 9, tells us what the ministers have to do.
Just before we leave section 1, the
Yes.
subsection 4,
Yes.
the commissioners shall comply with such directions as may be given to them by ministers.
Yes. Yes.
I did look to see if there's a power for ministers to give directions. Maybe it's implicit in that provision.
Well, yes, a relevant direction in this case might be the one at 17 capital B2 that we'll come to in a minute, where the minister, we'll come back to section 1, but it's on page 32. Skipping ahead to the appeal against restocking notice provision. 17 capital B, appeal against restocking notice, and if we go down to little 2, the minister may, after considering the committee's report, direct the appropriate forestry authority to withdraw the notice or to notify the objector it shall have effect.
That's direct in a different sense, though, isn't it?
Yeah.
That's dealing with the outcome of the appeal.
Yes.
Whereas what my lord is referring to is a general direction as to how they ought to exercise their functions.
Oh, I see. Well, if that's the, I'm not aware of any such general direction.
Well, but I'm going to ask you something about Mr. Minor's book on this when we get to it.
Yes.
Yeah. Anyway, so that's it. 8A you want
That's,
to
yes, 8A. In performing their functions under this Act, ministers shall have regard to national interest in maintaining and expanding forestry resources. So it's pretty clear, even before we get to the bits of the Act that deal with restocking notices, which takes these principles further, that we know what purposes and duties and indeed considerations are material. It's all the things that have just been set out. And I submit that a proper engagement and understanding with particularly Section 1, but also Section 8A when it comes to ministerial decisions, is absolutely critical, so that one can understand what matters then are important, relevant, unimportant, irrelevant.
No, in law, all this does is say that there is a consideration which must be taken into account.
I appreciate that.
It doesn't say it's the only consideration or that there's nothing else. It's simply a consideration. And
yes,
we've got to analyse things in legal terms, not in general terms.
Fair, yeah, of course, my lord, that's true. But an analysis of if an other consideration is said to be material, that analysis has to be put forward in my submission in terms of the scheme of the Act.
Yes.
We have to be drawn back in terms of a consideration of relevance to what those statutory purposes actually are, and so this is what they are. There are some more though that I'll show the court in just a moment. No, I don't need to really show the court 9, but I'll just note it in passing. So obviously it was a topic of much debate. Section 9 on page 11, the general requirement for a licence, and in particular 9.4D. It's obviously
But
very
9.4D
important.
is important.
Very
Your
important.
argument.
It's obviously I won't make any submissions about it now, but it's obviously very important to note.
Yeah.
I will just touch on before we get to 17 and following. 15, section 15.
Just for clarity,
Yes.
9.4D, granted or deemed to be granted.
Yes, I
think
it's
Mr. Minors makes maybe 2 points there. This is authorised by a planning permission,
Yeah.
so it doesn't have to be a planning permission granted on an application.
on an application could be under the
It could be a
GP, yeah.
permitted development
Yeah.
right pursuant to a statutory instrument.
Yes.
Deemed to be granted might refer to those provisions where planning permission is deemed to be granted, where you've got another statutory consent.
Yes.
For example, the Electricity Acts and that sort of thing.
Yes. And
Yeah, okay, but this is wider than we see in some other parallel provisions.
Yes, it certainly goes.
So you may not actually have to
Put in an application for permission.
Yeah.
Per se, you
It
either
may be a
maybe another
sufficient-
route.
It may be a sufficiently clear permitted development right, which makes it plain that you immediately require to fell trees. Okay.
Yes, yes to all of that. 15. So I suppose I will just, having said I won't make any submissions on it. 9.4 is a clear example of the interaction between the planning regime on the one hand and the forestry regime on the other. It's not the only one, but it's an absolutely critical one. Perhaps the next is section 15 on page 22. again, I won't dwell on it because it's not material to the facts of this case, but I note section 15 just because it is another provision where the Parliament are expressly considering the interaction between the planning regime on the one hand and the forestry regime on the other, because of the point about tree preservation orders. But I'd like to dwell...
This seems to be in a nutshell a situation where you've got an application for a felling licence, and there's also, when you consult the local planning authority, they raise an objection to the grant of the felling licence. That objection is not withdrawn, and then you turn over the page. This provides that the matter is then dealt with under the planning regime.
Yes, that's right. That's right. And so it's again
to avoid dual process.
Well, that's the point. And when the senior president talks about the statutory regimes working in synchronicity together, it's that kind of point that, in my submission, he had in mind, because it's the regime works, as I've submitted already, perfectly well so far as things are done in the right order. When Parliament wants the planning regime to take the baton, if you like, then that's what happens, or vice versa. Either way, it's all dealt with perfectly clearly, and there's no need for the interpolation of further balancings or the requirement to have regard to one thing when you're doing something else, but beyond that, for which Parliament has expressly provided.
But now, the reason why it's dealt with under the planning regime is in the second line of subsection 1, relevant consent is required for the felling of those trees. Subsection 1A, that's under tree preservation. Exactly. So presumably that's referring to trees which also are covered by TPOs.
By TPOs under the Planning Act. Okay. Exactly. That's right. And we have some of those provisions in this bundle. So we can see the corresponding provisions in the Town and Country Planning Act. It all fits, it all works.
It's also potentially quite interesting that the statutory priority is given to the planning.
It is. Well, it is. It is interesting. Yeah.
I mean, because if maintenance of trees were the primary consideration, you might...
I suppose
maybe you can't draw any.
It's a very difficult one, that is obviously what Parliament has provided for, but I suppose the caveat is that the planning system, as the point my lady made earlier on this morning, is capable of thinking of giving proper weight, sometimes determinative weight, to the interests of the environment and trees in particular. So just because the planning regime is dealing with it doesn't mean that the tree felling is going to happen or be authorised. It may well be that the planning regime decides in the other direction. But yeah, that either way, that's the system that Parliament's designed. That's my submission. And we get to restocking on page 29. Section 17, capital A. Obviously looked at this yesterday, and I won't go through it all in lots of detail, but I do want to draw the court's particular attention to what's said at subsection 3, which is not a subsection that we spent long on yesterday. This gives further considerations that are, well, they're effectively mandatory considerations for the Commission to consider when deciding whether to issue a restocking notice. Got to have regard to the interests of good forestry and agriculture and the amenities of the district, duty of promoting the establishment and maintenance of adequate reserves of growing trees, and indeed advice. I'm not aware of any relevant advice for the purposes of this case, but those are the three things to which they must turn their mind, all of which I say perfectly consistent with, might be said to be components of, their general duties and purposes at section 1. So that's what restocking notices are essentially about. Now I appreciate my lord...
So just for my...
I'm sorry.
The Regional Advisory Committee for a Conservancy, are those Forestry Commission policies?
Yeah, I was going to ask about that. Is conservancy defined anywhere?
I don't think it is. I'll take instructions on that question over lunch as to who they actually are.
There's an interpretation section, and it tells us quite rightly that Monmouthshire should be part of Wales. Yes. It doesn't tell us what a conservancy is.
Yes.
We'll have our trees back.
I will come back to the court after lunch as to who the relevant regional advisory committees may or may not be.
But this, of course, is what the forestry
yes, of course,
must take into account when they're issuing a notice.
Correct. Of course, that's right. That's quite right. So these provisions don't bind the minister as obligatory material considerations, but I do say that it obviously sets out
what exclude the potential relevance of other considerations.
Correct. I accept that with the caveat that I've given already that it all guides when considering the relevance of other considerations, one has to actually look at what the statutory purposes, relevant duties and purposes actually are. The appeal provisions at 17b over the page 32.
Yep. I would quite like to see the regulations on prescribed notice.
Yes, of course.
The prescribed manner. Yeah.
We've only, as I've said, we've only got, I think, a page of them or something in the, it's at page 70 of the, this bundle. There is only there's a page, but only a page, and what we can do over lunch is print off the whole lot.
Well, what I'm particularly interested in is the notice.
The prescribed form.
The prescribed form,
yep.
Because we're going on about discretion, but it isn't discretion, it's an objection. And the regulations will tell us what's got to be in the objection.
What
the
print off form.
Has to deal with is the objection in the prescribed form.
Understood.
Yep.
And we'll print that off over lunch. I don't at the moment have any further submissions to make about 17b, other than that we'll come back to the notice, the specified form. I think it's form 6a in the regulations. We'll provide that to the court after lunch. Taking a step back from, in particular, sections 1, 8a and 17a, my submission is that Parliament has told us three things. They've told us what the Forestry Commission's duties and purposes are, and also the ministers, C8A, for the purposes of this regime. They've told us that. They've told us, so the first, I said three, the first is they've told us what its duties are, the second they've told us what its purposes are. They've told us those two things. The third thing that they've told us is what considerations are material to the question of serving a restocking notice. Now, I accept what my Lord has said a couple of times, that they've not expressly ruled out other considerations as being potentially relevant. I do accept that. However, my submission is that when it comes to consider the potential relevancy or not of other considerations that aren't set out here, that relevancy has to be judged in light of what we know the relevant purposes and duties actually are. And the nub of it is that nothing in here comes anywhere remotely close to, my submission is allowing.
It's got to be allowing.
It's got to be allowing.
Quite frankly, it doesn't. If it's allowed, the fact that you've got to have regard to some mandatory considerations doesn't mean if something else was allowed and they looked at it and they granted it. It's like the children's duty. It's the primary in consideration to have regard to the best interests of the child.
Yes.
But there may well be other non-primary considerations
to which you have to. Yes. So my primary submission is that this
all or nothing. Really.
Exactly. My primary submission is all or nothing, i.e. that this legislative setup does not permit, say, the Forestry Commissioners in the first place, but then the Minister reviewing their decision on an appeal, to have regard to so-called planning considerations. Well, in particular, I want to be more specific about it. The so-called, by the judge below, general public interest in the delivery of housing. I said that is not something that the Act permits the Commissioners or the Minister to have regard to. And my alternative fallback submission is that if I'm wrong about that, and the statutory scheme does admit those considerations as you know, albeit not specified one way or the other, but the Secretary of State can think about them, that they were entitled not to on the facts of this case.
Yes, but the problem that you've got is once you're into they could have regard to the potential for future development,
Yeah.
either in an emergent allocation or by some other means. Once they can have regard to that, and if it is part of the objection, then they've got to decide what they think about it. They may say we're not giving weight to it, or we don't want to give weight to it, but they can't say we're not going to decide the objection because we think it's too difficult.
Yes. I mean,
that's the problem. That's why I think
I accept that, and I've accepted already the point about remit in the reference committee letter. If they're wrong about their remit, then they're wrong.
Yeah.
However, as I've said already, this is not a case like yesterday where there were no reasons given that related to the points that my learned friend was making.
But
there are
paragraph
reasons.
13 is critical, I think. If it's dealing with, as it seems to, the prospect for future development, and if that is a consideration that it would be permissible to have regard to, given that it is part of the objection, they would have to decide whether or not they were going to give primacy to that consideration rather than the forestry one. That's the difficulty.
I accept that. So if that is that second sentence of paragraph 13
That's
in the
problem,
court bundle, on page 218 for the court's note, if it is correct then that the reference committee misunderstood their remit, the remit as described there was to establish, quote, which of these public interests should take precedence. That's the way it's put. If they were wrong about that, then they were wrong.
Yeah.
And I would accept that if then the minister adopted that conclusion, the minister was wrong.
Exactly, because if it's an objection that can be properly made, she's got to decide it. That's her job.
Yes.
Yeah.
Yes, I accept that.
Well, it goes a little bit further. She precluded herself from addressing it by self-misdirection as to remit.
Correct. So she got her powers wrong, she got her vires wrong, she got her remit wrong. Yeah, so I have to accept that. So
It'll be a bad day in the office if you lose on that, yes.
Yeah, well, yes.
So you will be heartbroken.
Yeah. But so obviously my primary case, obviously, is that the reference committee...
I think it's got to be that. It just isn't a relevant consideration, your submission. It can't be a relevant consideration.
Yeah.
And that means that if she did take it into account, the Forestry Commission could have sought judicial review on the grounds that she allowed the objection when she shouldn't have it.
Correct. And that is...
as stark as that.
It is as stark as that. And so the question then, that's why I said right at the outset, I might get to finish my submission before lunch if I'm with a fair wind, but right at the outset I said that the question for the court is whether this so-called general public interest, etc., is indeed something that the minister needs to consider or not. And that is what it comes down to. It is in the sense of binary. And that's why, as my lord has alluded to in passing, but it is an important point, this is an important case.
Yes.
Because the facts aside, Arnold White was the first case where the Court of Appeal set down, not guidance, but set down a sort of a more thorough analysis of the way that these regimes work. This really is going to be the second. And it's the first one, really, where squarely this issue about the interrelationship between planning on the one side and forestry on the other has arisen almost in its sort of pure form. I mean, it's a binary question, and it will have ramifications, one way or the other, obviously, for many, many hundreds of cases all over the country. So that's that. Now, just to say in passing, I need not dwell on this because of the composition of this court, but to state what might be obvious, the planning regime is completely different. I've spent some time on the Forestry Act. I won't spend time on the Town and Country Planning unless you'd like me to. Obviously, the Town and Country Planning Act is completely different. There you're looking at, to cut a very long story short, the development plan, other material considerations, etc. And those matters that are capable of being material to the planning regime there's lots of very high learning on that from the Supreme Court, the House of Lords over many decades. My point is that it's a separate regime, and that Arnold White tells us how they are to interact, and the extent to which they are to interact. The answer to that question is they interact to the extent that Parliament has set out in legislation. I also say, and again, we have got parts of the NPPF, the National Planning Policy Framework, in the bundle. But I don't need to refer to it. It's obviously policy, not law in any event, but just to cut a long story short, government national planning policy in this country does not presume that, say, housing, for instance, or any factor, including the retention of trees or anything, should necessarily be prioritised over any other thing. It's paragraph 8 of the NPPF sets out a range of considerations that go into the government's definition of so-called sustainable development. And they are all, in a nutshell, to be balanced against one another. So when the judge talks about a general public interest in the delivery of housing, referencing the planning system in the judgment below, if that was the judge's summary of the approach that the planning system takes to the delivery of housing, i.e. that it assumes that or presumes that the delivery of housing is somehow sort of to be in the public interest to the extent of anything else, that's wrong. It is important to be clear about that, because that's not the way that planning operates. But planning does not make any assumption like that. It balances those matters under section 38.6 as the court well aware. I won't make any submissions on it to develop that unless, of course, you'd like me to. Arnold White.
Yes, so you've moved off to 67. I wanted to ask you about Dr. Minor's.
Oh, of course, sorry, Mother. Yes, you did say that you would. Yes, of course.
Thank you.
Sorry.
That we do have an authorities bundle for SMAR, and it's tab 12.
Yes, from 168.
Yeah, absolutely. And at page 170.
Yes, my lord.
Paragraph 17-1, second paragraph.
Yes.
He refers to the policy of the Act changing since the Second World War. And in 1958, government made it clear reserve of trees no longer an end in itself, blah, blah, blah. Further review of forestry policy stressed the importance of amenity. And then we see that on the 12th of April 1984, the Minister gave a direction that the Forestry Commission must consult with central government and also local authorities and other interested bodies to ensure that land use, amenity, recreation, so on and so forth. There's a reference to land use.
Yes, there is.
And amenity. What the Commission take from that is that amenity will be the principal consideration.
Yes.
I tried to find the direction, couldn't find it, but did find that in 2023, the Forestry Commission persuaded the Minister to withdraw that direction. So a bit of hokey-cokey going on. But there are really two things which interest me. One is consultation. Presumably there are regulations which set out consultation requirements for dealing with felling licences, felling licence applications. And
I think a ministerial statement rather than regulations.
okay, there is some sort of procedure for consultation which seems to involve perhaps local authorities.
Yeah.
But following on from that, are there any consultation requirements in relation to Section 17A notices? The consultation, I'm not asking for an answer now.
Well, the answer's
consultation, well, that's what I was interested in. Likewise, Section 24 notices, the subject of Arnold White.
No. The answer is no. On the consultation question, the answer is no.
So that may be an indication as to the ambit of the procedures and the sort of considerations which might be relevant.
My lord. Well, quite. I mean, these are quite. Yes, I accept that, and I rely on that because these are, as I'm trying to develop.
But it is odd that government directs land use to be taken into account. It might depend upon the terms used in the direction. But anyway, standing back from that, and the concept still in the statute, the concept of the of woodland as a reserve.
Yes.
We're now in the 21st century, where woodland is important as a carbon sink.
Yes.
And from my limited reading, it looks as if a direction has been given to the Forestry Commission that it should try to increase the percentage cover of woodland in this country to 16.5% by 2050, i.e. the year for the net zero target. I'd be quite interested to see where that's expressed.
Where that direction is expressed.
Yeah, because
I'll take some instructions over lunch.
That might be relevant to our understanding of how the scheme operates now.
Thank you.
Well,
all right.
and also, I mean, there is this problem. Looking at the section, the Commissioners shall, in exercising their functions, comply with such directions as may be given to them by the Ministers in relation to the exercise of their functions, that if this land use direction is given lawful, then it seems that land use is relevant, potentially, to their functions, because the Minister couldn't have directed them that you must have regard to it, if it was something that they couldn't have regard to it.
Except
It does rather unravel your submission.
Well, I need to. I'll
Yeah.
take instructions on the on what direction exists at the moment about my Lord Justice Holgate's point about 2050, etc. Over
But it's the other one,
lunch.
the 12th
Well-
April one. That's the problem. If you look at 170,
Once-
what the direction does is make it compulsory to comply with the direction.
Yes.
But so the implication is they might have been looking at land use, which you say they can't do.
Yeah.
But the minister was saying you've got to look at land use according to this book.
Right. I mean,
So
I
you need
will.
to think about that over lunch.
Well, I need to find out what directions are extant and what they say. So I will.
But my Lord is saying,
It's
not,
not that.
sorry.
Oh, I'm sorry.
It's been revoked, that direction.
I
and it's
see.
a different
Yes,
point.
but-
So it's not that there is now a direction, and that means that your arguments are wrong. The argument is a different point, as I just expressed it, that if the section
Yeah.
allows the minister to compel them to have regard to land use must be something that they would be able to have regard to. All the direction does is make them have regard to something they
Well,
could have regard to.
Well.
I mean,
So
the
if
trouble,
you-
the trouble
the
with this
difficulty
text,
with- sorry.
it's very compressed. It may
Yeah.
be the direction was focused on felling licenses.
Yes.
Because it's talking about consultation. And there doesn't seem to be any consultation arrangements for section 17A and section
Well, that's
24.
that's true.
Which is where Arnold White is applied. But
I
I,
do-
just think we need to be clear
We
about
do
the
absolutely.
framework.
We do. I do say that if it, well, I need to try and get the terms of the withdrawn direction. But
Yeah.
if it is right that land use that land use more generally was part of that direction, and then it doesn't follow necessarily that land use remains a potentially material consideration post withdrawal, because
Yes, it does, for this reason. What the section says is the commissioners shall comply with such directions.
Yes.
It's an obligation of compliance. The directions must have been requiring them to comply with something that they could lawfully take into account. If the direction has been withdrawn, they no longer have to comply with it. But it doesn't
Yeah.
alter the argument that it must be implicit that land use is something that can be taken into account. What the subsection does is elevate it from can to must. And that's the problem. And I mean, the government shouldn't be telling us, in this case, land use is a no-go area for commissioners and ministers considering objections. If the same government department has for decades been telling people that land use has got to be complied with,
Yeah.
but we just don't know. But the government will, I'm sure, be consistent.
I hope so. I'll come back to the court after lunch about
Yeah, on that.
the best I can do with an answer to the directions. On Arnold White, which was where I was about to go
Yeah.
next, I won't dwell on it because obviously I anticipate that the courts have an opportunity to
Yeah.
probably reread it. I'll just note in the to cut right into the senior president's judgment, a couple of paragraphs on which I particularly rely. It's probably obvious, but in particular, page 144 of the authorities bundle. Paragraph 64.
Just to remind ourselves, this was on the facts different, wasn't it?
It was
Because
different on the facts.
Requirement in the felling licence to
Correct.
restock.
Correct.
And they then had planning permission, it was approved, or they got approval of reserve matters.
Yeah.
And the question is whether the condition in the felling licence
Would sort of
Was-
fall away.
fell away.
Was in a
by
sense
the-
trumped,
Yeah.
but by the subsequent grant of permission. So different case on the facts, absolutely. But there's a couple of points of principle on which I rely, and these are points to do with an elucidation of the statutory scheme, really. Paragraph 64 on page 144, I rely on that. It corresponds obviously with
Sorry,
submissions.
paragraph.
64 on
Sorry.
page 144.
Thank you.
To do with the subsections that expressly set out an interrelationship where Parliament has seen the need to do so. That's that. Over the page, paragraph 68 is a development, as I read it, of what the senior president's just said at 64. He says he's already mentioned the first reason. He says that in a carefully constructed and self-contained statutory scheme for felling of trees, Parliament's explicitly dealt with the relationship and the separate statutory scheme for planning. It's provided expressly for the synchronicity between these two regulatory regimes, etc. In the final sentence, one may assume that it sought to legislate as fully as it considered necessary for the different scenarios which might arise. Absolutely rely on that. And then a similar way of putting fundamentally the same idea over the page at 71. The second sentence and on says the land use planning system and the legislation for forestry comprise separate but coordinated statutory schemes. They're among several regulatory regimes that can bear on the progress of development on a site. They don't belong in any sort of hierarchy. Parliament has addressed the interaction between them, etc., and that what one is not subordinated to the other. One can understand on the facts of that case why the court was concerned with this idea about subordination. But actually the same point, I appreciate it's a different fact pattern, but the same point arises here, because what was being sought to achieve, what my learned friend's submissions were seeking to achieve, was in effect the subordination of the forestry control to the planning system. The planning system coming along later and saying, here we are, we've got a planning consent now, and then being able to say, okay, well, that 10 years that you decanted for originally in your restocking notice, that should yield now to the planning system. So the idea about subordination, obviously directly relevant on the facts of Arnold White, but actually also has a relevance here too.
Yes, what you say is the possibility of planning commission can no more knock out a restocking condition in a felling licence than it can a restocking condition in a restocking notice.
Absolutely, the logic is the same. Appreciate the facts are different sections at issue in the Act, in both, well, in the Forestry Act, but the logic is the same. Judge below wasn't impressed with the relevance of Arnold White to this question, but I'd say that the logic is the same. And if I just crystallise, if I'm able, it depends on whether the court would be prepared to bear with me for just a few more minutes, and then
yes.
I can essentially
Yes,
finish subject to a point about the directions that I'll need to take some instructions on over lunch. Crystallise what I say about really draw together all of my submissions.
Well, 74 is relevant.
Oh, sorry, my lord.
where you
Yes.
in the first line. You're the same Mr. Simons, I assume.
Yeah.
That's me.
Yeah.
Yes, that was me. It was me then. Still me now. If growing trees were felled under a felling licence with restocking conditions and a grant of full planning permission was later applied
Well, this
for.
is the point, yes, that I was making, that you'd be looking at a bare plot.
Exactly.
Of trees, and this is a bit different because you'd be looking at a plot
Yes,
with little trees.
with some little trees, but that's true. So it is a bit different, but it does go to my lady's point earlier on about that the planning
trees.
system would be looking at a different status quo.
Well, the point's made at the end of the paragraph about both systems being undermined. If you could retrospectively get the benefit of section 9(4)(d).
Well, that's a good point, yes. It may well undermine, the senior president said, the interests of good forestry, compromising effective regulation of the felling of trees by both statutory regimes, forestry and planning. Might be thought to be consistent with the way it was put by the reference committee, but anyway.
Yeah.
Okay. But that, of course, that was the proposition that the judge below thought was irrational.
I wonder whether it would be better to pause now.
Yes, of course.
And for you to formulate how you want to bring your submission
Thank you.
together into a pattern,
Neat
and
package,
then it'll
yes.
be neatly packaged and marketed.
I'd appreciate, then I can have regard to whatever's in the, if I can
And
get
then
well
you
on
can
the
get your
directions.
people to look at whether they've been telling other people things for 20 years, which are different from what you're telling us today.
I'm grateful, my lord. Thank you.
Thank you very much, Mr. So 2 o'clock then?
Thank you.
Right.